crisis moment with the Zoom.
All right, can you post the,
Yep.
oh, I'll send you the link.
If you want, yeah. I'm just booting up.
All right.
Say, the way the DAS handles this is more like jeopardizing. It can jeopardize things the way they just inserted themselves, not knowing any of the background. That's just kind of sketchy.
Yeah.
Say, the way the DAS handles this is more like jeopardizing. It can jeopardize things the way they-
Ooh, that just played on YouTube. That just played on YouTube.
Wait on me too.
YouTube.
Oh, YouTube.
Ooh, that just played on YouTube. That just played on YouTube. Tube. That just played on YouTube. That just played on YouTube. Tube.
Good morning, Mr. Hanson, Mr. Epstein. Just wanted to let you know I see you there and we'll keep you on mute until it's time for your case to be heard. Thank you. And you can keep your camera on or not on, up to you. Good morning, Ms. Cox and Mr. Diggles. I think that's who Bill D is. I just wanted to say I see you there and I will keep you on mute until it's time for your case to be heard. You can keep your screen on, your video on or not while you're waiting. Thanks. Morning, Commissioner.
Hi, Amy. How are you?
I'm good. How are you?
I'm good. Just getting set up here.
Yep.
I'm going to put myself back on mute.
Okay. Good morning, Mr. Gould. Just saying, I see you there. We'll keep you on mute till it's time for your hearing. Good morning, Virginia Mariner Augusta. I think you're muted. Just checking to see what case you're here for.
She's getting her coffee.
Oh, is that Mr. O'Brien?
Yes, it is. Good
Oh,
morning.
okay. Good morning. I was actually talking to somebody else, but I'm glad to
Oh,
know
all right.
she's getting her coffee.
So did you get that, Patricia McNally?
Is this Miss McNally that you're working with?
Yes.
Okay, you may want to turn up your volume. It's really hard to hear you.
Is that better?
A little bit, but I would actually, if you can, bump it up even more.
Okay, is it better without my mask?
It is, yeah. And just so you know, I'm going to keep you guys muted until it's time for that case to be heard.
All right, here's Patricia.
Hi, Miss McNally. I'm Amy. I'm going to keep you muted. I keep everybody muted until it's time for their case to be heard. So I just wanted to let you know I see you there, and I'm going to keep you muted for now. Okay?
Thank you.
Okay. Morning, Commissioner David.
Good morning. Good morning. How are you?
I'm good. How are you?
I'm fine.
And I saw, nope, there's Commissioner O'Brien, coffee in hand. Your husband let us know. Nope, you're muted.
I don't have coffee in hand. He's gonna finish it.
Oh, okay then. Spoke too soon.
Yeah.
Looks like we are waiting for one more commissioner. Good morning, Commissioner Ashby.
Morning, Amy. How are you?
Good, how are you?
I'm well, thank you.
There she is. Okay. Good morning, Commissioner Dusan.
Good morning.
And can the person who just joined by phone, 510 something, let me know who you are and what case you're here for? You are muted right now, so you would need to unmute.
Hi.
Hi.
Hi, this is Lucy Wang. Hi, I'm here for the Crossman Airbnb matter.
Okay, and I'm sorry, I did not get your name.
Lucy Wang.
Lucy Wang. And I'm sorry, you are with,
Airbnb.
oh, yeah, okay, got it. Thanks very much. I appreciate it.
Thank you.
Okay, Amy, are we ready, do you think?
I think we are.
Yes.
Yep.
Okay. Good morning. I'm Deb Whitworth, and on behalf of my fellow commissioners, welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that there's silence now. You've received a link to the agenda, including the consent agenda. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission will vote on those cases shortly, and they will not be considered further today. The remaining cases on the agenda are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Before we get to the cases, let's get to the agenda. So could we have a motion to adopt the agenda and consent agenda? And Amy will remind commissioners that you
Yes.
have to vocalize your vote as well as raise your hand.
Thank you.
Madam Chair, I have a question probably for council or for Amy. I find I have a conflict in a case on the consent agenda. Does it make sense for me to abstain from voting on the consent agenda or asking to pull that case out and move the slate without that case or some other alternative?
I do not imagine we're going to have a problem if you abstain. So why don't we just have you abstain from the vote? Just because it'll be easier.
That's easier. Okay, good. Thanks.
So I'll move adoption of the agenda and the consent agenda.
Second.
So it's been moved and seconded. I will go through the commissioners one by one. You're as Commissioner Whitworth noted, I do need your each vote every time to be made audibly and also visually. So if you're saying yes, you agree to adopt the agenda and consent agenda. Commissioner Whitworth.
Yes.
Commissioner David.
Yes.
Commissioner Dusan.
Yes.
Commissioner O'Brien.
Yes.
And Commissioner Ashby is abstaining. And so that passes.
The commission meetings of January 2022. Is there a motion to accept or amend?
Move we accept the minutes.
Second.
So it's been moved and seconded. I'll ask each of you if you agree. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Dusan,
Yes.
Commissioner O'Brien.
Yes.
Thank you.
Director's report. Amy.
Yes, good morning again. So you have some memos. One is a memo about it's a typical personnel memo. It tells you our sad staffing woes and just how seriously it's actually impacting the agency at this time. And I didn't mention in the memo that I put out a letter to all the people who practice here to let them know on our website about a month ago. So it's a really, honestly, this is I think the toughest time I can remember in the 10 years that I've been here, just keeping the office operating. So we're working on basic functioning at this point, and hopefully in March, things will ease up a little bit. We do have some new staffers who will be joining us, but front office being largely out for a span of 3 months is really challenging. So everybody here is pitching in incredibly, but I just wanted you to know, normally we don't bother to tell you about sort of daily staffing things, but it's gotten to the point where I thought you ought to know. So there's that, personnel. Compliance, you have a memo that shows that there are 6 cases actively in conciliation. And since the last meeting, we have 2 unsuccessful conciliations and 1 successful conciliation. So I have 2 agreements for you to review and hopefully approve of. One is that occurred during the conciliation period. So that's the 90 days after a reasonable grounds finding. That is in H210272 Norwood versus Strictly Mobile Homes. And then there's another agreement that had been negotiated during the conciliation period, but wasn't fully signed until after the period ended. And so we have a second agreement to be approved in H210127 Malcolm versus the Apartments at Brunswick Landing. So if you would be so kind as to make a motion or motions on each of those, that would be great. We could get those conciliations moving.
I move that we approve the conciliation agreement in, can we do them both at the same time?
You can, yep.
In both H210272AB and H210127AB.
Second.
Thank you. So the motion is to approve both agreements I've presented to you, one in H210272 and one in H210127. So as if you say yes, you're agreeing to approve both conciliation agreements. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Doosan,
Yes.
Commissioner O'Brien.
Yes.
Thank you. So I appreciate that. Next up on the director's report is typically us telling you how many cases were filed in the prior month, but I can't tell you that because the system that we have relied on for probably 20 years, which is provided by the EOC, they shut it down as of December 31st. And the new system that they've put in place is lovely, but is not issuing reports yet. So our own internal database is not 100% up to providing those reports, or it could be probably a more accurate statement is that I don't know how to run a report in there yet to get you that information. But I can tell you that as of now, we're sending out complaints received at the end of January and we're in the 50s. So we received probably about 50 something complaints in January, but we'll get you some accurate data for the next meeting. We did manage to squeeze out of the old nearly defunct system a closings report, which allowed us to tell you that there were 3 predetermination settlements. In actuality, all these numbers I'm giving you, there's a lot more of them. They just haven't been entered in the databases that calculate these numbers. So what we had reported from January was 3 housing settlements. And the only reason that they're in the system at all is because they're housing, because they need to be done so quickly for HUD. And 2 administrative dismissals, again, because they're housing. We did issue 12 right to sue requests. Now I have a pile, I think I said this last month, of probably 50 to 60 cases waiting to be closed, but because they're not as time sensitive, I haven't gotten to them yet. So sometime soon, maybe hopefully in March, there'll be a much bigger number on the closures report. That's all I have. I would ask that we take litigation after executive session. And then I can just tell you, and I'm sorry, I just saw a message saying somebody noticed that Alice Neal is signing on as being at Pine Tree, and a commissioner saying, did I miss something? Alice at Pine Tree, and this was actually in the personnel memo that Alice departed the commission and went to take on a fantastic, exciting job at Pine Tree Legal Assistance, being their primary housing attorney for housing enforcement, fair housing enforcement. I'm sure I have said that wrong, but so yes, you did that. You briefly missed it, but now you're up to date. With respect to new business, there's only a few, really the only things I wanted to mention relate to the legislature because it's going on right now. This is the short session, so typically only emergency bills or what the legislature considers an emergency or possibly an emergency. We had a public hearing last week. I think it was last week, could have been the week before, on the commission's the only bill that we introduced this session, and that related to a Whistleblower Protection Act jurisdiction that the commission has over in workplaces that have unions. And it was a response to a law court decision last spring, or it could have been winter. Again, not sure. And we had the public hearing, we have the work session coming up. I haven't seen it on the schedule yet. There were a few other bills that relate to the commission that we appeared about, nothing dramatic or new. We presented our Government Evaluation Act report. If you remember, I sent you a copy of this big, thick report. We presented it to Judiciary, and apparently we have still another hearing, which I did not know. This whole process is new to me. Another hearing at which they, I don't know, bless us to continue operating. I'm not entirely sure, but that's coming up, I think, in the next couple of weeks. And we will be having our supplemental budget, as will all state agencies, coming up, but we haven't gotten any notice of when that will be. So that is what I have for new business.
Sorry, I was muted. So we'll take a break for 4 minutes and we'll get back at it at 8:45.
Thank you.
It's 8:45. I don't know if all of our commissioners. I think we need to wait for Jill.
Here she
There
is.
she is.
I
Okay,
just didn't have my thing on.
okay. So let's get back to our meeting. It's 8:45. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions. And I will ask that you introduce yourself as you're called. Thank you. The first case on our agenda is PA 19-0487-A and B, Madeline Thompson Crossman v. David Malay and Airbnb. This is a reasonable grounds recommendation. So could we hear from the respondent first?
There are 2 respondents, and I would propose to hear from Mr. Malay first, or his counsel.
Thank you. Good morning. My name is Ed Gould. I'm an attorney in Bangor, and I represent David Malay. I want to thank you all this morning for hearing us. I'm going to concentrate on 3 arguments, 2 raised by Airbnb in their letter, and 1 that we raised relating to reasonable accommodation. The first issue I'd like to address, the first 2 issues that I'd like to address is the applicability of the public accommodations provisions of the Maine Human Rights Act to this case. Issue number 1 relates to the provision in 5 MRS section 4581, which is the fair housing subchapter of the Maine Human Rights Act. But if this exception to the Maine Human Rights Act applies to this case, it's clear that the case should be dismissed, and I'll explain. Section 4581 subsection 4B2, excuse me, states that the act does not apply to cases where there is a rental of not more than 4 rooms in a 1-family house where the owner resides in that residence. That is the case here. Mr. Malay did not rent out more than 4 units of his home where he resided. The only question here then is whether or not the provision, the Fair Housing Act, providing this exemption also applies to the public accommodations subchapter. What's determinative in my reading of that issue is that the exception in the Fair Housing Act does not limit its application to the subchapter containing the provisions relating to fair housing. It explicitly states that these exceptions apply to all cases under this chapter. And of course, that chapter is chapter 337 of Title 5, which is the entirety of the Maine Human Rights Act. Therefore, if we give the plain meaning of the statute its plain meaning, because this is a situation where Mr. Malay did not rent out more than 4 units and resided in the house, that provision of the act does not apply to Ms. Thompson Crossman's claim. The second issue I'd like to address with you is the definition of public accommodation and a place of public accommodation. In the definitional section of the Maine Human Rights Act, section 4553, A place of public accommodation is defined as a facility that's operated by a public entity or a private entity. It does not say that it applies to something that's operated by an individual or a person. It's specifically limited to public entities or private entities. If we look for more definition of public entity, it's not there. There is a definition of private entity, which says it's essentially anything other than a public entity, but it continues to use the word entity. And what is significant is if you look two subsections prior to this definition in that the definitional statute, it provides us with the definition of person, which includes individuals, which is what Mr. Millay is. Reading these provisions together, it's fairly clear that when the legislature enacted the public accommodation provisions of the Act, it intended it to apply to entities such as corporations, municipalities, LLCs, but not to persons. If it intended the public accommodations provisions of the Act to apply to persons, it would have included that in the definitional statute. The legislature declined to do that. So again, we have to give meaning to the plain language of the statute, namely that persons such as Mr. Millay are not covered by the public accommodations provision of the Act. Finally, I'd like to address the issue of reasonable accommodation. It's clear under section 4592 and the public accommodations subsections that operators of a public accommodation are required to make reasonable changes to their policies and procedures in order to accommodate people such as persons with a disability. The investigator's report does not explore this whatsoever. The reasonable accommodation provision certainly would have, if the Act applied to Mr. Millay, the reasonable accommodation provisions would apply as well. As we all know, the reasonable accommodation provisions of the Maine Human Rights Act require a discussion between the parties to try and reach an accommodation of a person's known or unknown disability. The investigator's report does not address that whatsoever. And for that omission, I believe that the investigator's report should be rejected by the commission. That's all I have to say. I'd be happy to address any questions from the commissioners. And I'd also like to reserve 2 minutes of time. Thank you.
Muted myself. You can reserve 4 minutes because that's what you have left. Questions? Do any commissioners have questions for Mr. Gould? If so, raise your hand. I will call on you in turn. Okay, I see first Commissioner Ashby and then Commissioner David.
Thank you, Mr. Gould. So with respect to your first argument, isn't this situation here, the business arrangement that your client finds himself in, isn't it analogous to that of an innkeeper and not a renter of apartments?
Well, that's not the way that the exception's written in the Act. I mean, I understand sort of the common sense analogy that you're trying to make, but what the Act specifically says, it does not prohibit, the chapter does not apply to the rental of a one-family unit, the rental of not more than 4 rooms of a one-family dwelling that's occupied by the owner. This was a rental of a room in a one-family dwelling occupied by the owner.
Doesn't that analysis, though, turn on your definition of the term rental, whereas in Maine law, I think historically, a public accommodation, even with an innkeeper, is by definition not a rental?
Well, public accommodation certainly could be broader than a rental, but the transaction that we're talking about here was the rental of a room in Mr. Millay's residence for a period of several days.
Okay, moving on, your second argument about this private entity. You don't know this, but I run a law firm as a sole proprietorship. Are you suggesting that I'm not subject to the requirement that I provide public accommodations to people without discrimination?
If you're operating your law firm as a solo and not in the form of any professional corporation, then my argument is that the public accommodation provisions of the act do not apply to you.
Okay, thank you.
Commissioner David?
Yes, good morning, Mr. Gould.
Good morning.
Two questions. What would you envision? Well, let me ask you this. What is the exact timeline of discovery by Mr. Millay of the disability of the proposed rentor of her mother?
I'm sorry. My understanding is that shortly, excuse me, before Ms. Thompson-Crossman's mother was to arrive, that there was a telephone conference between Mr. Millay and Ms. Thompson-Crossman, in which Ms. Thompson-Crossman raised the issue of her mother's dementia. So
it's that day.
I believe so, yes.
Okay. And what, in your view, would the reasonable accommodation process look like? Should it have looked like?
Well, of course, we don't know because it wasn't explored by the investigator. But what I would envision is that Mr. Millay raises some concern, which I think were justified by the fact that Ms. Thompson-Crossman said that she planned on spending at least the first night there because of some concerns about her mother's dementia. From that point in time, there should have been a discussion between Ms. Thompson-Crossman and Mr. Millay regarding specifics about how she was affected, what her limitations were, what some potential hazards for her may have been presented by the physical layout of the dwelling, and perhaps some accommodation could have been reached. Perhaps not. We don't know because, again, that issue wasn't explored. But at least there should have been a discussion involving the specifics of Ms. Thompson-Crossman's mother's condition and whether or not the physical layout of the facility could have accommodated those issues safely.
That's what I'm concerned about. We normally don't concern ourselves with the specifics of the disability, but there's a whole universe of disabilities and accommodations. I mean, it could be I can't accommodate somebody in a wheelchair because there's no lift, which is completely different from whether we can what the extent of a dementia is. And your argument is that process was not done.
Well, my initial issue is that issue wasn't explored by the investigators, so we don't know what potentially could have happened.
Okay. And well, part of this is a question for my counsel. I don't quite understand. Are you making an argument about conflict of interest of this board hearing this case?
No, I'm not making that argument.
You're not? Okay. All right. I'm okay. Thank you. A bit surprised at that, but that so be it.
Any other commissioner questions for Mr. Gould? Seeing none, we will turn to counsel for Airbnb.
Good morning. Yes, that's me. Thank you. Good morning. Thank you for the opportunity to appear before you this morning. I'm Stephanie Schuster with my co-counsel Douglas Currier on behalf of Airbnb. I'd like to please reserve 2 minutes for rebuttal. The Commission should adopt a no reasonable grounds finding as to Airbnb for several reasons, which are set out in our papers. This morning, I'd like to highlight 2 overarching reasons why a no reasonable grounds finding is warranted here. First, Airbnb did not deny the complainant access to its platform. To the contrary, Airbnb's immediate response to the cancellation of the reservation was to offer to help the complainant find another booking using the platform. Second, Airbnb cannot be liable for the host's actions, both because, as Mr. Gould explained, the host is not subject to the MHRA, and because Airbnb in any event lacks any authority to force a host to accept a person into his or her home. Starting with direct liability, Airbnb did not discriminate against the complainant. The host canceled the reservation a few hours before check-in. Responding in real time to a time-sensitive situation, Airbnb's demonstrated priority was to contact the complainant and offer to help find an alternative booking. And the complainant did, in fact, find another booking using Airbnb's online platform. At no point did Airbnb deny the complainant access to its platform. That is simply not the claim in this case. The investigator has recommended finding direct liability against Airbnb based on the investigator's conclusion that Airbnb's online platform is a place of public accommodation. We disagree with that conclusion because it's inconsistent with the law court's holding in Jackson that the definition of place of public accommodation reveals, quote, an obvious emphasis on some physical place or establishment. But that disagreement is really beside the point because Airbnb's platform isn't the place at issue in this case. The complainant does not and could not claim she was denied access to Airbnb's online platform. She claimed she was denied access to a room in Mr. Malay's home. Airbnb does not own that room and it does not control that room, and the investigator did not find otherwise. So even if Airbnb's online platform is a place of public accommodation, that is not grounds to hold Airbnb liable for a claimed denial of access to a different place of public accommodation. Now, turning to vicarious liability, Airbnb cannot be held liable for the host's actions for several reasons. Most fundamentally, as Mr. Gould highlighted, Mr. Malay and his room rental are not subject to the MHRA. Now, the statute specifically defines rental for purposes of the entire act as, quote, the lease, sublease, or let, or otherwise grant for consideration the right to occupy premises not owned by the occupant. It is not time limited in short-term rental or to short-term. The word rent, as used in section 4581 and its exemption for the rental of not more than 4 rooms in one's home, clearly encompasses what we have here. And it's not unusual, I'll point out for the commission, Title III of the Americans with Disabilities Act, in which the public accommodation provisions are modeled, likewise exempts from the public accommodation provisions the rental of not more than 5 rooms in one's home, analogous to the exemption that applies here. And additionally, just looking at the plain language, as Mr. Gould highlighted, the 4581, while it appears in the fair housing or the housing accommodation subchapter, explicitly says this chapter does not apply to the rental of not more than 4 rooms in one's home. Elsewhere in the exact same statute, other paragraphs uses the term subchapter to more narrowly refer to the fair housing provisions. And as the law court recognized as recently as last year in the fair elections case, when the legislature uses different words, especially within the same statute, that difference has to be given meaning. Now, apart from that exemption, Mr. Malay and his room rental fall outside the public accommodations provisions, again, as Mr. Gould explained, because Mr. Malay is an individual and not a public or private entity. Now, this is also not unusual. Title III of the ADA, likewise, does not concern itself with individual liability. It applies only to entities. So Commissioner Ashby asked the question about a sole proprietor law practice. If that sole proprietorship was formed as some form of entity, then it would come within the purview. But otherwise, the act simply just does not apply, and neither does federal non-discrimination law. And finally, and most importantly from our perspective, even if Mr. Malay were subject to the act, Airbnb could not be liable for his actions in this case. No matter what Airbnb's role is in the management of its online platform, there is no dispute that Airbnb lacks decision-making authority or control over a host's home. Airbnb cannot, legally or practically, force any host to accept any person into their homes. A finding against Airbnb here would punish Airbnb for not accomplishing that impossible task. So I'll reserve the remainder of my time unless there's additional questions, but we respectfully submit that the commission should adopt a no reasonable grounds finding in this case. Thank you.
Thank you, Ms. Schuster. Any commissioners with questions for Ms. Schuster, raise your hand. I see Commissioner David.
Am I correct that Airbnb advertises the amount of money and accepts the money, and in this case made the refund?
Correct. Airbnb acts as a payment processing agent, so we'll collect the money and we'll process the refund. That's the limit of its role.
Does it matter to your argument whether or not the public or the users perceive Airbnb to be responsible for the accommodations?
Well, I think just as the premise of the question, the users agree to the terms of service, which is a legally binding agreement that's binding on the user. And the terms of service make very clear that Airbnb does not own or control the accommodations, that it's the host that provides the services, and that Airbnb is not party to any agreement between the host and the guest.
I take it that means that when I go to Airbnb, I'm expected to read the small print, and I have no idea whether that's a half an hour or 3 days of small print. I've never used the platform, but.
So it's a good question, Commissioner David. So what happens is when you create an account and when you go through a booking, there is a process flow where you're presented with you can't proceed unless you acknowledge in one way or another that you have reviewed the terms of service. Now, failure to read them is not an excuse under the law, but that opportunity to review them and giving notice that your use of the platform is going to be subject to them is sufficient under the law to form a binding agreement. It's referred to as a click wrap agreement.
And if I could just say, I'm not sure that all of that was in the record.
Yes.
Thank you. You referred to, you didn't refer to, as I understand it, Mr. Millay calls you as this is happening. Do you counsel him about what action he should take in terms of? Sorry,
go ahead.
Good. No, that's the question.
Yeah, that's not in the record, Your Honor.
Okay.
So it's not in the record.
Actually, the investigator has corrected me, saying how the terms of service works was presented by Airbnb. So my apologies. Go ahead.
No problem.
But you referred to counseling him, right?
No, we do not. No.
And you have no responsibility to counsel him when he calls you and say, what do I do with this situation? I have a woman that may have dementia and I'm concerned about it.
So again, what he said when he called was not in the record. And if you're asking me, I can provide it, but I don't want to exceed the rules of the commission. But what I can tell you is,
okay.
Yeah, but what I can tell you is that the act does not regulate whether we counsel someone or not, what their obligations are under the law. What the act regulates is the action of denial of access to a public accommodation. And here, we had no ability to control whether we educated him, provided him advice or not. No ability to control whether or not he canceled the reservation and let someone into his home.
But you have an ability to delist him if you find he's discriminating. And I take it, well, maybe the record doesn't reflect whether you've done that or not.
Yeah, we have the ability to prospectively remove folks from our platform. But again, that still does not translate into the ability to force someone to accept a person into their home. We simply just legally and practically cannot do that.
Thank you.
Any other questions from commissioners for Ms. Schuster at this time? Seeing none, Ms. Schuster, you have about 5 minutes left when we come back to you. But at this time, we will turn to complainant, Ms. Thompson-Crossman.
Good morning. I think I can be brief. I would just note that I'll just make 2 points. First, that the exception in 4581 is titled housing accommodation exceptions. It refers to the rental of housing, and housing accommodations defined under the Act is housing offered for residential purposes. That was never contemplated here. There was no tenancy or residential housing intended or offered in this case. So I would argue that that this was a public accommodation, and that exception does not apply to this public accommodation. The definition of public accommodations under the Act also contemplates that a private home, a private residence may double as a public accommodation. I'd also like to note that Airbnb relies on Jackson versus State, a 1988 case predating the internet, for its position that an internet space, that a public accommodation must be a physical place. But what was held in that case was that the licensing, permitting, or regulating function of the government is not a realm that can be that is within the public accommodations that are regulated by the Act. What we're talking about here is much less abstract. This is a website that is open Airbnb is a website that is accessible to the public, where goods and services are offered to the public, which is the essence of a public accommodation. I'd also note that the commission did find in 2019 in Sarchi, its decision in Sarchi versus Uber, did take the position that Uber, which is a closely analogous to Airbnb, it's an internet platform where private persons offer rides to one another, that Uber, the platform that manages that, was a public accommodation. I think I have nothing further. I'll reserve the rest of my time. Thank you.
Sure. Commissioners, any questions for Ms. Thompson-Crossman? If so, raise your hand. Seeing, Commissioner David?
Ms. Thompson-Crossman, how do you respond to the argument that there should have been a discussion about a reasonable accommodation that was not had here? Probably because of the time frame. Is it first, I guess, backing up, is it correct that the initial indication of her disability was the day you were checking in, or you called before you got there, or that kind of thing?
That's correct. Yes. And I do think there's an argument that my offer to stay with my mother for the first night, or for further nights if necessary, was an offer to engage in the reasonable accommodation process, which was essentially shut down by Mr. Mellet, by Respondent Mellet. He did not engage any further. And it may not have been reached in the investigator's report, simply because that aspect of the process was not reached. The decision was made simply to deny services.
It's significant to me. You just said the first night or other nights. The investigator's report says you offered to spend one night, and that seems to be directly relevant to the discussion about the extent of her disability or possible disorientation or whatever.
I may be mistaken, so I would revert to whatever is in the investigator's report, which was investigated while that was much more fresh in my mind.
You're not sure whether you offered to stay more than one night?
I'm not certain, no.
Okay.
I don't want to go beyond what is in the record.
Thank you.
Commissioner Ashby?
Isn't that a bit of a red herring anyway? Do you understand the law to require a disabled person to request a reasonable accommodation because the respondent has some concerns about a disability?
Thank you. No, I don't. I do believe that it would be the responsibility of the hosts to engage in that process once a disability has come to light. But I would consider that my offer to stay with my mother was my portion of participation in that process.
Okay, thank you.
Any other commissioner questions for Ms. Thompson at this time? Seeing none. All right, now we're going to go back to the respondents. And first we'll go back to Mr. Gould on behalf of Respondent Mellet. You have 4 minutes, Mr. Gould.
Thank you. First, I want to raise the issue of the definition of housing accommodation that Ms. Thompson-Crossman raised. Section 4553, subsection 6 specifically says housing accommodation includes any building or structure, and goes on with other definitional language. It's not exclusive. It includes that and does not exclude the application of the exception that we're relying on in this case. Secondly, I just want to briefly touch on the reasonable accommodation issue. As we know, in virtually any disability discrimination situation, that when you're involved in the discussion of a reasonable accommodation, the issues of the extent of the individual's disability, the person with the disability or the person acting on behalf of the person with disability has much greater knowledge about the extent of that disability than would someone in Mr. Malay's position. He had knowledge and concerns about the physical layout of his residence. He had concerns because of his background that a person with dementia might be at risk under that physical, with that physical layout. But he didn't know the extent of Ms. Thompson-Crossman's mother's disability. That's why there is a two-way discussion that's involved here, and that's why there is some responsibility on the part of the person with a disability or the person acting on their behalf to engage in that process. Thank you.
Any follow-up questions for Mr. Gould from commissioners? If so, raise your hand. Seeing none. Okay, we're going to move now to Ms. Schuster. Ms. Schuster, you have 5 minutes remaining.
Thank you. I'll be brief. Just to touch on and piggyback on the housing accommodation that the argument the complainant has made. The exception does not use the term housing accommodation. It's just in a paragraph title. It says, it's simply, the operative text is the following exceptions apply in this chapter. And we go down, and the rental of not more than 4 rooms in a one-family dwelling in one's home. So the rental is the key word. And again, as I read the definition of rental, it is not limited to housing, into long-term housing, which is, again, consistent with Title III of the ADA and makes sense for why that exception is more broad than referring to simply the fair housing subchapter. And second, on the issue of the Jackson case predating the internet, the fact that the case predates the internet is not reason to reject the law court's interpretation of statutory text. The text has a fixed meaning, and that meaning the court interpreted not to be more expansive than a physical place or establishment. But again, I would remind the commission that whether or not Airbnb's platform is a place of public accommodation is truly beside the point. Because again, the complainant has not urged and has not made a claim or a charge here that she was denied access to that online platform. That's all I've got. So thank you again for the opportunity to appear.
Any follow-up questions for Ms. Schuster from commissioners? Mr. David?
Ms. Schuster, how do you react to the argument that you're in the same legal category as Uber, which I can tell you impresses me? Uber, you know, like Airbnb, holds itself out to the public, controls the rules, takes the money, assures the public that it's supervising either the transportation or the residents, et cetera, et cetera.
So I think my response to that, Commissioner David, is that one, whether Uber in its online platform or a place of public accommodation is still controlled by the law court's decision in Jackson. It's binding precedent from the High Court. But second, again, regardless of what analogy there is, and I don't want to speculate about the differences between Uber and Airbnb. Again, there was no claim here of denial of access to Airbnb's online platform. The claim is denial of access to a room in the host's home. And again, Airbnb lacked control or any authority to force the host to accept someone into his home.
Any other commissioner questions for Ms. Schuster? Seeing none. Thank you, Ms. Schuster. Back to Ms. Thompson-Crossman. You have about 7.5 minutes left.
I don't think I need to add anything. Thank you.
Okay. So commissioners, then we would turn to the investigator, Jane O'Reilly.
Good morning, commissioners. My name is Jane O'Reilly. I was not the investigator on this case. This case was investigated by investigator Alice Neal, but I have read the full record and the report, and I concur with the investigator's findings. I'll start by pointing out a few sort of factual pieces of information that I think are important given the questions by commissioners. One is the conversation that complainant had with respondent Malay regarding how many nights she was going to stay. So what I have is the correspondence on the Airbnb platform. They look sort of like text messages. The message from complainant is, my mother has medical conditions, so I will be staying with her for the first night to make sure she doesn't get confused. And then in a subsequent message, part of the message says, in our phone conversation, oh, I just lost it. In the phone conversation we had after I told you about my mother's medical condition, I told you that I plan to stay with her at least for the first night and for the subsequent nights if it seemed necessary. So those are the facts that are in the record regarding the conversation about how many nights complainant offered to stay. So going from that, I just want to address a couple of things. I'll start first with the legal question of the interaction with Airbnb. I'm actually going to defer that to Commission Counsel. So if you have any questions about Airbnb's arguments about liability, I'll just point out the facts in the record that the investigator used to rely on their analysis in that instance, which is that there's definitely evidence in the record that there was a conversation with respondent Malay and Airbnb before he decided to cancel the reservation. We don't know what was said. It is true that Airbnb has not referred to that as a counseling or a guidance or anything like that. Those are Mr. Malay's words, respondent Malay's words. But the beginning of his, the first message that complainant received saying that the accommodation would be canceled says, I've discussed this matter with an Airbnb representative and offered to refund all monies received by us related to your reservation. So there's definitely in the record indication that there was some discussion had and that Airbnb provided some information to Mr. Malay. So that's what the investigator relied on. And then before I go to questions on that for Commission Counsel, I'll address this question of a reasonable accommodation. And I'll go back to Commissioner Ashby's question regarding the legal obligation. It may have been complainant's position that she was willing to engage in this conversation and make these offers of offering to stay, but there was no legal obligation to for her to engage in a reasonable accommodation process based on respondents' concerns, which is, I believe, how Commissioner Ashby posed the question. Just because she disclosed a disability and respondent had some concerns about that disability, complainant did not. The analysis in this case is not a reasonable accommodation analysis because there was no reasonable accommodation requested and none needed. The discussion was an offer by complainant to stay just to make sure her mother was comfortable, and she was willing to engage in more of to stay longer in order not to lose the reservation. But there was no obligation to engage in this reasonable accommodation discussion because there was no reasonable accommodation requested. Additionally, if the response, I will stay for one day, is perceived as an opening, I'm offering to stay as an accommodation, complainant is also correct that immediately in response to that, Mr. Malay canceled the reservations. So even if there had been some opening to a reasonable accommodation discussion, it was Mr. Malay who ended the conversation and said, no, I have concerns. I'm canceling the reservation based on these concerns. There was no opportunity for complainant to even suggest an alternative at that point. I think those are all the issues I wanted to present. I'm happy to answer any other questions about the record and direct all questions, especially regarding the issue of the housing and public accommodation to our Commission Counsel.
So commissioners, I see Commissioner Whitworth. Any commissioners who have questions for the investigator, raise your hand and I'll call you in the order I see you. I see first Commissioner Whitworth and then Commissioner David.
This might be a question for Commission Counsel, but why was this not done as two separate cases? Why was it done as one case?
It was investigated as one case because it's based on the same set of facts. So sometimes we can separate and the same basic claim, denial of a public accommodation. So the liability issues were argued differently under different standards because you have the provider and then you have Airbnb, but we often combine our investigations and our analysis in one report if it's based on the same set of facts.
So the follow-up question then is, if we find reasonable grounds or not reasonable grounds, Mr. Malay and Airbnb will get the same finding.
No, you can find differently against different respondents. If you want to make a finding I believe at the end of the report, even if the findings are combined in the same paragraph, which I will glance to see if they are.
They are, but you can separate them
You
out.
can separate them,
Okay.
absolutely. So that was a formatting. Sometimes we combine them, sometimes we separate them. And the complaint, sorry, I should have also mentioned, the complaint was filed against both together, which is another reason we combined them in the report. The complaint was against both Malay and Airbnb, so we investigated it as one case.
Okay,
Yes.
thank you.
Commissioner David, questions for the investigator?
Yes, thank you. Thank you, Jane. That was very helpful, and I think very important, although others may not. The business about offering to stay more than one night. As you can tell by my questions and by that comment, I think that the accommodation issue is right to the fore here. So I want to ask you. You say no accommodation was requested and none needed. It's the none needed that I want to ask you about in this situation, in which the disability, normally you're saying that the person with the disability requests an accommodation. Well, in this case, by definition, the person with the disability probably did not have the wherewithal to make that kind of request, and the request is being put on the table or being brought up by the agent, by her daughter. So why do you say there's none needed?
I would just say I'm not aware of anything in the record that would indicate that the complainant's mother did not have capacity or had a legal guardian. Just wanted to address that one point. That's sort of supposition.
And Jane, if you need me to jump in, I can.
I'll start with the facts and then I'll defer to you to. So yes, what Executive Director Sneerson said is correct. All that's in the record is that the complainant was making the reservation, which anyone can do for anyone. There's no capacity issue. There's no legal authority issue. Complainant filed her case not on behalf of her mother, on behalf of herself. There's no capacity at issue in this case. So to go to the reasonable accommodation question, an accommodation is something generally that the would be requested by an individual in order to access services. In this case, the mother was completely capable of accessing the services. Complainant was simply providing some information to respondent, but that she was not legally obligated to provide that information. That was voluntary, and she was not providing the information in order to get any kind of accommodation from respondent. So that's why I say the accommodation was not requested. And in this case, there's no evidence that the accommodation was needed because there's no evidence in the record regarding the mother's inability to access the accommodation. And Barbara, you can add on to that in terms of.
No, that's exactly what I was going to say. As a matter of law, the reasonable accommodation process, it's a reasonable accommodation to allow the individual with a disability to use and enjoy the place of public accommodation. In this case, the person who seemed to want an accommodation was the provider to make themselves more comfortable. And that is not the purpose of a reasonable accommodation process. The accommodation needs to be for the individual with a disability, not for the service provider. And it is up to the individual with a disability to decide whether or not they need to request accommodations.
Okay, thank you.
Any additional questions for the investigator? Seeing none, thank you, Jane. Did commissioners have questions for counsel at this point? I know you might, as we go, just want to ask. Seeing none. Okay. So we have heard from the parties and the investigator. And so at this time, we would be looking for a motion or motions. As Commissioner Whitworth was asking, it is totally fine if commissioners want to split up the respondents into different motions. They were presented in the report all together, but
I think it makes
Also-
sense to do that. I'll move that there are reasonable grounds to believe that respondent David Malay discriminated against complainant on the basis of disability, and that conciliation should be attempted in accordance with the act.
Second,
so it's been moved and seconded to find reasonable grounds to believe that David Malay violated the Maine Human Rights Act. I'm sorry. Any discussion? That's what I'm supposed to
I'll
say.
be really brief. I don't understand the argument that they're not a private entity. I don't understand that argument. I don't agree that this is excluded under the fair housing provisions of the act. This is not a fair housing case. It's a public accommodation case. And I just want to stress, this is not this is not a reasonable accommodation case at all. It's absolutely, I think Mr. Commissioner David's sort of fallen into a bit of a trap that a lot of us fall into, and that is that, and that's discrimination per se, when someone who discriminates against someone on the basis of disability says, oh, your disability is so problematic for me, I think that we need to talk about me deciding what accommodations are appropriate for you. And that's exactly contrary to the concept of reasonable accommodation. So it was a bit of a red herring. We went down a rabbit hole, but I hope we're back where we need to be on that issue.
Commissioner David?
Thank you. That's directly to the point and has directly changed my mind from, what I had decided yesterday afternoon as I'm reading through the cases. And I have been educated about that process, Commissioner Ashby, and I thank you for that, and I thank council for that. I was indeed in that stumbled and went down that hole about the respondent deciding what the accommodation process needed to be. So I am persuaded and will join in that motion.
Any other discussion from commissioners on the pending motion? Seeing none. And Commissioner, just FYI, Commissioner Doosan is abstaining from this vote. So all those in favor, not all those in favor. I will ask commissioners one by one. The pending motion is to find reasonable grounds to believe that David Malay discriminated, violated the Maine Human Rights Act. If you say yes, you're in agreement. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien. Oh, you're muted.
Yes.
Okay, thank you. So that motion passes. Is there another motion?
I'll move that there are reasonable grounds to believe that respondent Airbnb discriminated against the complainant on the basis of disability, and that conciliation should be attempted in accordance with the act.
I'll second.
Is there any discussion among commissioners?
I'm convinced of vicarious liability. I think this is analogous to Airbnb, or even I was thinking Napster in this case, actually.
Napster.
I do believe, contrary to the arguments made by counsel, that this entity does in fact exercise control over its users. As indicated by Commissioner David, they have the power to terminate their involvement with Airbnb, and that's known to the respondent at the time of entering, I assume, entering into the contract, and so that's the ultimate control. I'm interested in the fact that there was actual communication between an agent of the respondent, Airbnb, and the respondent, Mr. Malay, prior to the decision, the ultimate decision to cancel this reservation. I think we would have heard from Airbnb that what that communication was, if it was in its favor. My guess is, and Airbnb acknowledges that it otherwise does require its patrons to follow all the laws. And in this case, the appropriate thing would have been to take all efforts, even if they were unsuccessful, make all efforts to stop the act that was so overtly discriminatory, namely canceling the reservation.
Commissioner David?
I agree. That's the one thing that I was clear about coming into this, was that Airbnb stood or fall with Mr. Malay if there was discrimination, and we found that there was. They hold themselves out, they take the money, and it's crucial that they have that conversation, they have that intercourse with their provider that they're controlling. I think it's on all fours with Uber and those other kinds of cases and that these are technicalities that are just trying to avoid responsibility and reap the profit.
Other discussion among commissioners on the pending motion? Seeing none. So the pending motion is to find reasonable grounds that Airbnb violated the Maine Human Rights Act. If you say yes, you're in agreement. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien. Nope, you're muted. Couldn't hear you.
Yes.
Thank you. So both findings are reasonable grounds, and the commission will send all parties and council a letter reflecting that and the next steps in the process. And we thank you for being here.
Okay, on to our next case, PA 20-0069, Robert Kanzler v. Town of Freedom. This is a reasonable grounds recommendation. So could we hear from the respondent first, please?
And if I could just say before the parties start, I forgot to give the request to all parties that I normally do at the start of a hearing, that you not mention the names of any third parties or witnesses. We've given them all pseudonyms or other names in our reports, so we thank you for that. I'm sorry, Deb, you had just called the Kanzler case from the Town of Freedom. I believe that's Mr. Kelly.
Yes, good morning, everyone. Can you hear me?
Yes.
Okay, thank you. So I represent the Town of Freedom as well as many other municipalities, and that's why I'm here today. I did provide you with fairly detailed materials on what we believe the facts demonstrate. To the extent I need to, I guess I'll make my request to reserve time. It's a bit of an advantage to go second today in that I got to see the process and I'm not sixth. So thank you for putting me second. Unfortunately, I have to cast this case in what the facts demonstrate and request that the commission not be a shill for the complainant's purposes in the Town of Freedom. And I think the record factually demonstrates that the commission is being used where Mr. Kanzler's purposes have failed. He's politically active and physically active in opposing most things done by the select board. He has run for office and failed. He has sought to have select board members removed with recall votes and failed. He's alleged pretty much everything you can allege in terms of failures of the select board in his arguments over the last several years. Corruption, illegality, spending decisions, ethics violations, and notably abuse of power. Perhaps the best visual I can suggest is Mr. Kanzler sitting on an ATV in a snowstorm, stopping a snowplow from plowing a public road. I think that sort of sums up how we got here in terms of perhaps the motivation. The building itself, as you may have read in my materials, is an 1875 Grange, and it is not perfect in terms of today's standards. But as I understand it, the discussion is whether or not architectural barriers have been removed, and that is the focus. The building has 2 access points, and I did include what I think are more clear photos in my materials dated January 4th. These were in my original submission back in April of 2020. So the building has 2 access points. One is on the road, and as you'll see in the photograph, it is basically flush with the grade of the road, which goes by the Grange Hall. When you go into that space, you can take a stair elevator, so to speak, a stair lift up to the 2nd floor. 2nd floor is the only building in the Town of Freedom that they find large enough to have their annual meeting, and they've been doing that since 1946 in this space. So there is access from the first floor on the roadside. On the back, and there's one issue, and I've indicated in my materials, there's not competent evidence for you to find that this is not an accessible 2nd floor from the 1st floor. Because as in the investigator's report, The statement is that the entrance is still not entirely accessible due to uneven surfaces that must be navigated. And the record doesn't have any facts, doesn't have any photos, doesn't have any measurements, doesn't have anything to support that finding. The second access point on the building is on the back side. And it's not the prettiest ramp that the world's ever seen. It's clearly something that was done on site by the folks, probably the Grange Hall folks. And it was done at the same time the chairlift was put in on the lower side of the building. But importantly, both sides are accessible to grade, both the front and the back side. If you look at the photograph, the ramp is not even as long. If the door fell down on the ramp, the door would be longer than the ramp. It's probably about an 8-foot ramp. And the grade at the base of the ramp is a parking area with essentially 3 handicap spots. So if there's an elderly person or a person in a wheelchair who has to get to town meeting, and that, by the way, is the only use the town of Freedom has for this building, it's at the annual town meeting. So on the back side of the building, if someone needs to access it, they are driven up to this ramp, and they are literally just feet away from the entrance. And there is volunteer folks who help with that. The door is the Grange building's door. It has a push bar on the inside. And what they do is accommodate folks by having the door open and allowing them to have basically volunteers physically help them into the building if they choose to go on the back side of the building. The record indicates that people with wheelchairs or other disabilities frequently attend on the second floor, not just the town office annual meeting, but also for the Grange Hall events. There is no evidence, competent evidence, that there was a disability here in terms of some mobility problem of the complainant. The record reflects that he was active, not just on his ATV in snowstorms, but also in terms of going in and out of town hall and walking and hiking, and apparently advertising to others that he walks and hikes. What essentially happened here was the gentleman refused to use the stair lift if supposedly he needed to use the stair lift, if that wasn't indeed the case, and instead he used the stairs. In fact, in the meeting when the vote took place as to whether or not the town should move its town meeting to an abutting town, the complainant was there and refused to use the elevator and walked up the stairs. On that point, I want to highlight that for a second. Despite the fact that there was significant political and personal disagreements between Mr. Kanzler and the rest of the select board, they still took the trouble in this case as an effort to advertise and man and staff with election wardens a special town meeting to have the decision looked at by the population. Should they move town meeting to another town with a larger building that was a brand new, essentially brand new or very recently built school? And the vote took place and the town took that effort, and it was a 33-1 vote against moving town meeting. And by the way, yes, it's a flatter surface in that school. It's built for handicap accessibility in ways that new construction public buildings are, but it's about 175 feet to get from the parking lot into the building and what people would have to navigate. Now compare that with the current situation where we have about an 8-foot ramp and a car that can drive right up to it, and someone that will help you if you are in a wheelchair by opening the door. It's not perfect, but does it remove the architectural barriers? And I would suggest yes, that has occurred. So I'm going to stop speaking because I did submit a fair amount of detail in my materials, and thank you for your time.
Thank you. Questions for Mr. Kelly from commissioners? I see Commissioner Ashby.
Hi, Attorney Kelly. I read in the record or in the investigators' findings that there was a 2017 incident in which this complainant indicated he had gone up the ramp. The door had no knob. He then had to go apparently down and use the other entrance. And I know that's outside the 300 days. Does the record have any other, and this is, I want you to focus on what the record shows. does the record have any other evidence that this complainant had a problem with accessibility to the Grange home?
No, and there was no accommodation request within any specificity after the town meeting, special town meeting, in which the town did not vote to move the town meeting. Secondly, the one reference of perhaps another accommodation issue is in one of the rebuttal statements filed by Mr. Kanzler, and he focuses on this uneven surface, and he specifically says that other folks might have a problem with that, but he did. There was no allegation that he did. So the answer is no.
And as I understand it, the record does tell us whether or not he needs, say, a wheelchair or any other adaptive equipment, and that's in the negative. Is that correct?
That is correct.
I have no questions. Thanks.
Any additional questions from commissioners for Mr. Kelly? Commissioner David?
Would it not have been fairly easy to smooth out the lower entrance? Those are fairly minor lips as I look at the photographs. I mean, it's why didn't they fix it? Why didn't they make it level?
The photographs don't depict what they're alleging. The allegation is that inside the building there's some uneven surface.
Okay, I need to know that. I didn't understand that. The allegation is not that what the photograph is showing there is a lip between the pad and the sill of the door is the barrier. He's not saying that.
Sorry, not that I understand it, and I never had an opportunity to address that issue. It was in a rebuttal comment, and I've never seen exactly what the uneven surface is on the inside of the building.
Any additional questions from commissioners for Mr. Kelly? Okay, you'll have about 2 minutes when we come back to you, Mr. Kelly.
Thank you.
And then the question is Mr. Kanzler present? I have not seen his name so far. Is Robert Kanzler here? I do not see him. In which case, Mr. Kelly, if you want to use your other 2 minutes, you can. Or not.
I was muted, sorry. No, thank you. I've said all I can say, thank you.
Okay. At that point, we would go to the investigator, Kit Thompson-Crossman. So again, and you're going to have this more and more these days as investigators are taking cases from other investigators. Kit did not do the investigation. They're presenting a report that Milo Gitchos had done.
Good morning, everyone. My name is Kit Thompson-Crossman. As Amy just said, I'm presenting Milo's case here. I did just want to clarify something that was just said. The issue with the first floor entrance is on the outside, and I think it says that in the report, in the fact section, the first full paragraph on page 2 of the report. There's a concrete pad just outside the door that's not level with the ground, and second, the threshold of the door itself is not level with the pad. Complainant did provide a photograph that's much clearer than I think anything you've probably seen of the lip up onto the concrete pad, and then the lip up into the doorway on the first floor. The only other thing that I would point out is that on the second floor, and I think this is also in the report, there's no knob on the outside of the door, so there's no way for somebody who was trying to use that door to get in unless somebody on the inside was opening it for them. And there's also no landing on the ramp. So if somebody was in a wheelchair, they would roll up to the door, assuming they could open it from the outside, roll backwards down the ramp, and then have to somehow roll themselves back in while keeping the door open. It's not a significant grade, but it is definitely a grade. And if you were in something wheeled, I imagine that would be difficult, as Milo pointed out. Other than that, I'm happy to answer any questions that you have based on what I've seen in the record.
Commissioner Ashton.
Hi, the record, though, doesn't indicate that this complainant is in a wheelchair, correct?
He's not. The record indicates that he has vision problems, COPD. and difficulty walking upstairs or walking long distances.
And the record doesn't indicate that this complainant had a problem navigating those small lips in the back entrance, correct?
On the first floor entrance, no, it doesn't.
And you agree that, as it argued by counsel, that it is not we address complaints by complainants. We aren't, like, for example, let's assume I share the concern that the ramp could use a flat surface at the top of it. If this complainant hasn't had a problem with the ramp, it's not our duty to, it's not even our charge to say to the respondent, you could do a better job building ramps or even eliminating small lips, right?
It is true that the only thing in the record is that at a point in time outside our 300-day jurisdiction, complainant attempted to access the building using that ramp, which was easier for him than using the stairs. The door was closed, he was unable to access the building, and so he had to go downstairs to the first floor entrance and use the stairs to access that space.
And I wasn't articulating it very clearly, but the complainant can't make a complaint on behalf of the general public, right? The complainant has to make a complaint that addresses concerns raised by the complainant. This is a question of whether or not the complainant has been discriminated against.
Yeah, that would be my understanding. Barbara, do you want to add anything to that?
Yeah, I would point out that the Maine Human Rights Act makes it unlawful to have certain buildings that do not meet accessibility standards. So the fact that complainant pointed it out, there is even if he was not affected, he has brought a case where there is, at least according to the report, it's up to you all, a technical violation of the statute, and we have routinely made findings on those technical violations. I would also like to point out that the individual making the complaint, you need an aggrieved person, but also that the commission could have filed this complaint. Anyone from the commission has the authority, whether or not they're aggrieved, to file a complaint.
Sure, but we would still need evidence, would we not, that the modifications to the building are in fact deficient, and that the best evidence would be that someone had a problem accessing the building as a result, right? I mean, we have no evidence that someone in a wheelchair had a problem with that ramp. Even if I personally think, boys, it'd be better if they had a flat surface at the top. We don't have any evidence that any person has ever had a problem with a wheelchair on that ramp, right?
Well, we have whether or not it was with a wheelchair. I believe Kit just said, and I don't remember the facts of this case, that the complainant had trouble navigating, and anyone with a disability who didn't want to walk up the stairs would still face the problem of there's no handle on the door.
Right.
Right. More than 300 days ago, that happened, more than 300 days prior to the filing of the complaint. But the respondent, and it seems to be unrebutted, indicates that the door is kept open, and there are people who greet folks who come to the town meeting at that door.
I will say, Commissioner Ashby, it's not clear to me from the record one way or the other, and I want to be clear. But the only thing that's clear to me is that at the beginning of a meeting, the door is open for people to come in. It appears that complainant tried to go to a meeting and that door was closed. So it may be that after a certain amount of time, there isn't anybody at the door to let people in. Maybe it was just that one time. The record is pretty bare as to facts about that, I will say.
Right. Thank you.
And I do see Commissioner Doosan had a question. I will go Commissioner Doosan and then Commissioner David.
Trying to make some distinctions in my head here. There's no dispute that there are two lips at the front entrance. And there's no dispute that there's not a flat surface. Both at the back entrance, the issues are no flat, no landing, and you can't actually open the door. I don't, and it's in evidence from the complainant that there was an attempt more than 300 days prior to access the building, and it was problematic. So I'm not at all sure that there's a requirement that, knowing that facility is not accessible, I'm not at all sure that we want to hold the complainant to a requirement that they keep trying. That they have to arrive again, try to get in, and have difficulty. Because as far as I can see in the record, the respondent has not taken care of the physical accessibility challenges. Am I missing a piece there in the facts in the file?
No, the only thing I think I'd point out is that I believe I heard Attorney Kelly dispute the lip on the front entrance, but there are pretty clear photographs in the record of those two lips. No, I don't think you're missing anything. I think those are the facts as I understand them.
Okay, thank you. I did hear respondent's attorney dispute whether the lip was there, but then I thought I heard you say that based on your review of the photographs,
yeah,
there is indeed the lip.
Based on the photographs that are in the record.
Okay, thank you.
Commissioner David?
Yes.
And after that, Commissioner O'Brien, I see. Yeah.
Yes, Kit, I heard you just say when you were describing his attempt, whether it was 300 days ago or not, he goes to the back door, he can't get in, he goes downstairs, goes in the front entrance and has to walk up the stairs. Isn't there a lift that they put in?
There is a lift which he refused to use for reasons that I don't understand or
So
know. They're not.
He refuses to use it. He's not complaining about the lip between the concrete and the sill.
No, he doesn't have a mobility issue. As I understand it from the record, he doesn't have a mobility issue that would make those lips hard for him to navigate.
Well, isn't the case about architectural barriers?
Yes, and he believes that those architectural barriers that they would pose a barrier for other folks who, for example, I think he pointed out, were using like a walker or a wheelchair or something like that.
Okay. Can you take me through this? I'm confused about this business about costs of repair and whether it's over $100,000 or not. Are you saying that the town had an obligation to fix that lip at the front door? I agree that the upper ramp is inadequate. There's no handle and there's no landing. So a person alone has to back away from, even if there was a handle, but the lip at the bottom, do they have to fix that?
So the reason that we care about the cost of the renovations is that if you look at the statute, there's a bunch of different standards for buildings that were built after a certain period of time between a certain years. The building in question, the Grange, was renovated in a time period where one of those would apply, except that there's an exception in the statute for renovations that cost less than $100,000. The evidence in the record is that the renovations that the town undertook cost less than $100,000. So the only statutory issue is removing architectural barriers. And so the issue in the investigation is whether the ramp at the second floor entrance and the concrete pad and the threshold at the first floor entrance pose an architectural barrier to somebody with mobility issues. And the complainant has argued that they do.
So if the repairs were to cost more than $100,000, they would have had to fix it, but this is the exception to that because it didn't, right? Is that correct?
I can't, well, so I'll just remind you again, this one wasn't my investigation. So I know what's in the record and what's in the law, and that's it as far as questions that I can answer. And I can't say for sure that they would have been required to fix anything. The standards get very, very, very technical, and because they didn't apply in this case, I haven't reviewed them that thoroughly. So I don't know if they would have been required to fix that lip.
I assume that they thought they were fixing the Grange Hall for accessibility by the community because they paid for the lift, right?
They put that's when they installed the lift. So yes, right. I think the sort of the central question here is they did attempt to address the architectural barriers and didn't go far enough to actually address them.
Okay, thank you.
Sure.
Commissioner O'Brien? Oh, you're muted. There you
Yes. I don't know if I'm missing something, but the respondent, Town of Freedom, and I I guess I'm confused as to why, I mean, the comment that Attorney Kelly mentioned about a shell game. The only, as I understand it, the only use that the town has for this hall is the town meeting. So why, maybe you don't know that, why wouldn't the respondent be Grange? Because I don't know who said it, someone else said that there are public, there are other events there. So.
Oh, I don't know that there are other events there. The town. So the town holds its annual town meeting there. And I understand that it's the town that undertook to address that. It's the town that installed the chairlift and the ramp. So I guess I'm not totally clear. I can check if you'd like whether the town actually owns the building, but they were responsible for the renovations and therefore for their effectiveness or lack thereof.
So, so are you saying that the precedent was kind of set because the town did pay for the lift, then consequently that means that they are that they are responsible because they initiated the original, that they are now responsible for the rest of it. You follow what I'm saying?
I do, yeah. And I'm just looking at the record to see if it doesn't appear that the town owns the Grange Hall. Yeah, and like I said, this wasn't my investigation, so I'm not totally clear on who owns it or who ultimately is responsible for the renovations, but the town uses it for its public meeting and therefore at least has a responsibility to try to make it accessible for the folks who are going to that meeting, I would think. Barbara, did you want to add anything? No, I see that you're unmuted and
I didn't realize I was, and I apologize if I've been blowing my nose publicly.
Before we go to Commissioner Ashby, Commissioner O'Brien, were you finished? Okay, Commissioner Ashby.
Well, and uncertainty around that issue is probably why we're talking not about making changes, minor or otherwise, to the structural aspects of the building, but to talk about moving the town meeting to a different town, right? Even though this isn't a reasonable accommodation case, I understand that the request by the complainant is to move the town meeting to some other town. So we aren't even talking about fixing the little lips or putting a flat spot on the top of the ramp, right?
my understanding from the record that we are talking about both.
Okay.
The complainant was very thorough.
All right, thank you.
Any other questions from commissioners for the investigator? Commissioner Dusan, did you look like you're thinking about it?
I do have a question. I'm pausing because I'm not sure whether it's appropriate to ask this question at this point, or if it's a question I should hold for commission counsel at some other point. So I've lost track of where we are in the case.
We are so far, we've heard from the party, one party, and now the investigator. And so the next thing we'll do is entertain a motion or motions from commissioners.
I'd start by, oh, sorry. I was going to say I would start by asking Kit, Jill, and if Kit feels like they can't answer it, they know what to do.
Okay, so now is the time to ask, because Kit, we are now asking questions of Kit.
Yes.
Okay, so my query, I keep just wanting to make sure I'm not going down a rabbit hole. The town has an obligation to hold the town meeting in an accessible location. Am I missing that as just a base point?
I think that's accurate.
Okay. And so a resident of the town who wants to attend the town meeting, if it's in a location which I think the record is showing is not accessible or has accessibility problems, then that member of the community can attend the town meeting. And so what came up most recently was the discussion of whether the town would move the town meeting to another location, whether in this town or in another town, another location, which is accessible or which takes care of the problems with the current location, with the Grange. Then we have in the record, or during the respondents' council's presentation, the discussion of there being a vote, a referendum on whether to move the meeting. And I have trouble getting to that, because if there is an accessibility problem with this location that makes it a not accessible location under the rules, under the statutes, then the town can't by popular vote decide that they're not going to have the town meeting in an accessible location. Am I missing something? Can I really by popular vote decide that I'm going to waive the rights of people with disabilities in my community?
No, I think you're understanding that correctly.
Okay, I'm cool. Just making sure I'm not off in the weeds somewhere.
No,
thank you.
I don't think so. Thank you.
Commissioner Ashby, I see you. I know you want to make a motion. I just want to check first if there's any other questions for the investigator. Mr. Kelly, we do not hear from the parties at this point. No other questions for the investigator? Okay, thank you, Kit.
Great, thanks.
I move that we reject the findings of the investigator and find that there are no reasonable grounds to believe that the respondent discriminated against the complainant and that this case should be dismissed under the Act.
Second.
So it's been moved and seconded to find no reasonable grounds to believe that the Town of Freedom violated the Maine Human Rights Act. Is there any discussion among commissioners? Commissioner Doosan?
Yes, I want to have a little clarity around the kind of standing issues that Commissioner Ashby mentioned, and I just want to make sure I understand what the response to that was. I think I heard Commission Counsel argue that that this complainant can bring this case to us, that there's not an issue that he didn't himself attempt to access the building within the statutory time period and find it that he could not get in.
Is that a question you're asking of Barbara?
I'm asking Barbara.
Darn it, I was hoping if I just let you talk, you would forget that there's a question. So yes, the complainant can bring this case. The question is whether, given the limited information in the record, I mean, it seems clear that this particular individual could have accessed the building if they wanted to, but it's also clear that they are concerned about accessibility. They have driven by, I believe is in the record, that they keep driving by to see whether it's been fixed so that they can access the building. And as I mentioned in the past, even if we have found that, for example, we have people all the time who file complaints about job applications that they didn't fill out. And these are, again, you can find a technical violation of the statute without finding that this particular claimant was harmed. We have done it in the past routinely with this sort of violation, which doesn't mean that we're going to do it this time. I'm just saying, yes, there is standing here. I'm saying it's taking a very long time to do it, but I'm saying.
In support of my motion, I'll suggest that there's no evidence that any person has ever had a problem accessing within at least the 300 days prior to the filing of the complaint, the Town of Freedom's location for its town meetings. There's no evidence that any person has. I see no evidence in the record that indicates that there's any shortcoming whatsoever of anything that the town has done. I may have my own opinion about whether that ramp should have a flat surface at the top. My opinion is just my opinion. There's no evidence in the record that any person has ever had a problem accessing the Town of Freedom's location for its town meeting. Furthermore, it's not a reasonable accommodation. Not that that's, I guess that's part of our analysis, but it hasn't been requested. It's not a reasonable accommodation to move the town meeting to a different town with all the limitations identified in what that move would make.
Commissioner Dusan, I was going to ask if you were finished or if you had some follow-up.
Physical accessibility to a place of public accommodation. You don't have to have someone in a wheelchair attempt to get up on a sidewalk before you are required to meet clear standards, technical standards about ramps, about accessibility for in the event someone with a disability needs to access the public space. And so I understand and I respect my fellow commissioners' passion on the matter. But I'm inclined to find even a technical failure to meet accessibility requirements is a problem. It's kind of a chicken and egg thing. I'll stop there.
Any other discussion among commissioners? Commissioner David?
Yeah, it is kind of a chicken and egg thing, Jill. But this is not their building. It's the Grange Hall. As I understood the business about the costs, I mean, they spent $91,000 making it accessible, and nobody else has had a problem. So I'm not sure that they fulfilled that the complainants fulfilled the burden to prove that it's inaccessible. I agree the ramp's inaccessible, but they built a stair lift. They put in a chair lift. That's all.
Any other discussion from commissioners on the pending motion?
Just lastly, it's a public use. You can't hold court hearings, for example, in an inaccessible space. It is, for me, it's the base that the town has a responsibility to have its town meeting to which all the residents of the town should have access in an accessible location. And so and this location is technically not accessible. So you don't have to have tried and failed. If you're sitting at home with a disability and you know that you can't get in the building, yeah, I'm not sure when it would ever come to be put in question. Never mind, I'll stop there. I think I know where I am, and I'm fine if I'm not in the majority.
Thank you, Commissioner Dusan. So the pending motion is to find no reasonable grounds to believe the Town of Freedom discriminated against Mr. Cancel or is in violation of the Maine Human Rights Act. If you say yes, you are in agreement with the no reasonable grounds finding. Commissioner Whitworth?
Yes.
Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner Dusan?
No.
Commissioner O'Brien? Yes, I got you.
Oh.
So the vote is 4-1. The motion passes and the finding is no reasonable grounds to believe unlawful discrimination occurred. We thank the parties for being here. The commission will send a letter reflecting that motion. And with that, we move on to the next case.
Yep, our next case, E20-0304, Nicola Cox v. Cumberland County Sheriff's Office. It is a no reasonable grounds recommendation. So could we hear from the claimant, please?
I did see Ms. Cox before. I don't.
Yeah, she's with us.
Oh, I'm sorry. Yes, people, your boxes move around. I apologize. Good, Ms. Cox, you have 10 minutes, and please don't mention the names of anyone who's a witness, okay? Oh, you're muted right now. There should be a little microphone button and you can tap it. I think Ms. Cox is muted at the moment and we're hoping that you can unmute.
I think she's seeking assistance.
She is, yeah, I'm just telling the person who just came in the room. There you go. Thank you.
Thank
So you have 10 minutes, Ms. Cox.
First of all, Amy, I want to thank you for rescheduling this because I had a conflict. I appreciate it. I filed a complaint because of a letter that someone wrote for me on October 28th of 19. The letter was about pass down, what goes on in pass down in the sheriff's department before each shift. There's a pass down that tells us what happened the shift before. Well, I wasn't aware of what was going on in pass down until this person wrote this letter for me. And the letter was saying that when I am not there, they insinuate that I should retire, that I'm old, or I'm out with my boss, my former boss. This letter that was written was signed by 13 officers. The officers state they agreed with the writer that this happens in pass down. I was under the impression once this letter was given to the sheriff and HR that it would be handled. Time went on, nothing was done. I made an appointment with the sheriff and the sheriff didn't know whether it was an HR thing or what, if it was an IA thing. At that time, he asked me to go ask the people who signed this letter to write their own statement. I didn't feel I should. They signed the statement. And to me, it was a form of intimidation for these people to be called out to write their own statement. They agreed with the writer. After this went on for a while, I went out on stress leave. And in the findings of the county, they said this didn't affect me. I went out on stress leave for 6 months and then I came back. When I came back from stress leave on September 17th of 2020, I was having a conversation with my lieutenant. My lieutenant made inappropriate remarks about me and my former boss. They were so bad, I was humiliated. I went into the major's office with another female to discuss this. And I asked him if the other situation was taken care of. And he said, how do you know it wasn't taken care of? I said, well, it wasn't obviously, because a year later, I had to write up a lieutenant for the same thing of harassment. This has been going on for a couple of years now. It's very hard for me to go to work. Every day, I feel like they're pushing me to retire. I've been there for 35 years. I've always been good to the sheriff's department. I have a good track record of my job. So I feel every day when I go to work, it actually makes me sick. I'm sick to my stomach all the time. Nobody at the sheriff's department right now represents the staff. HR doesn't represent the staff. The sheriff's department doesn't represent the staff. So we have no place to turn. So the only recourse I had was turn to the Maine Human Rights Complaint. I don't understand why they said that I didn't have any rights, that the founding was unjustified. Well, they never interviewed the writer of the letter. They said this was all hearsay. It was not hearsay because the writer wrote the letter. They never interviewed him and asked him if this was going on. In the letter that he wrote, there's two main characters in the letter that were part of the harassment. Both of them have been let go at the jail. Don't know the reasons, but I think it was conduct issue. So at this time, I feel that the commission should be on my side. I've tried my best. Like I said, the investigation was never handled properly. I think when you investigate and someone writes a letter to the sheriff and to HR, you should interview the writer. The writer had all the facts. He was never interviewed. I have a letter in there from a former lady who worked. She was forced to retire for the same reasons, her age. She went out on sick leave also. So this goes on at the Cumberland County Jail, and it's still getting worse as the morale gets worse, as you can understand, with 65 officers down. So I'd like to have 2 minutes of rebuttal if that's possible. I'm not sure. I'm not an attorney, so I'm trying my best. Thank you.
Sure thing. You'll have about 4.5 minutes left when we come back to you, but first I'm going to see if commissioners have any questions. Commissioners, if you have any questions for Ms. Cox, raise your hand. I see Commissioner O'Brien first. Go ahead.
Thank you. Doesn't matter if you're not an attorney, you're doing fine. But I guess you used the word about the letter that it insinuated about your age. So could you speak about that letter if you're allowed to? More, I mean, was it that generally the attitude of the pastor, I think it's called, the attitude of the group is about specifically you, and do you know what I'm saying?
Yeah. In Pass Down, the writer wrote all the names of the people that were involved. He wrote the names of the people that were involved. They would say, when I am not there, I'm out with my boss, or I'm old, why don't I just retire? When the writer wrote this, he was in Pass Down all the time. He was there when I was not there. So this is why I don't understand that the writer was never interviewed. The county is saying this is hearsay. It's not hearsay. If they would have talked to the writer, he was a witness to this. And he brought it to my attention because I always thought highly of all these people. And then we brought this letter to my attention. It was devastating. It was devastating. So, and then after this happened, then I had a lieutenant a year later make some awful remarks to me about my former lieutenant also, which totally humiliated me. I don't know if I should get into what he said or not, but he humiliated me. So I went to the jail administrator with the write-up when I wrote him up. And I said the other incident wasn't taken care of, which is the letter that was written for me. And he says, how do you know it wasn't? I said, well, obviously it wasn't, because on September 17th, the lieutenant made some awful remarks to me also. I can't hear you.
I believe the commissioner is saying thank you.
Thank you.
All right, thank you.
Any other questions from commissioners for Ms. Cox at this time? Seeing none. All right, so I'll mute you for now, Ms. Cox, and then you'll have more time at the end.
Yep.
And then I believe Mr. Bauer is here for Cumberland County.
Yes, I am. Thank you, Amy.
Go ahead.
Thank you very much, and thank you, commissioners, for your attention today. I appreciate it. I am Bob Bauer from Norman, Hanson, and Detroit, and I represent the citizens of Cumberland County and the sheriff, who is responsible for operating Cumberland County Jail. And Ms. Cox is a longtime employee of the jail, valued employee of the jail, and I just want to say to her, thank you for your service over these many years. Ms. Cox did make a complaint of age discrimination with the commission. The complaint implied, it made an age discrimination complaint, but it implied also a retaliation charge, and later a sex discrimination charge. So I'll start with the sex discrimination charge. The investigator looked into this. This was an incident that occurred, as she pointed out, later on in the timeline of the case, and involved one supervisor making a comment, an inappropriate comment about Ms. Cox's relationship with another supervisor in the form of teasing, but certainly an inappropriate comment. The comment was made in front of that person's supervisor, who also did nothing to stop it or made any, took any steps. After Ms. Cox complained about that, the matter was brought to the attention of senior leadership at the jail. Both the perpetrator of the comment and his supervisor were disciplined. The discipline was grieved, and the county manager sustained discipline against both individuals. So that matter, standing alone, was managed by Cumberland County and the jail, and the behavior did not recur. At least that's the understanding that we have, and that's what's in the record. Secondly, with respect to the retaliation charge, there's really been no actionable conduct whatsoever on the part of Cumberland County or the jail. There's been no adverse employment action. The employee continues her long career with the sheriff's office, and the only retaliatory, possibly retaliatory behavior that was identified in the record was moving Ms. Cox's office, or her workstation, if you will, from the middle of the jail lobby to the entranceway of the jail. This happened while she was on a family medical leave from about January of 2020 until June of 2020. Obviously, during that time is when the COVID pandemic really struck hard, and particularly hard in congregate living facilities such as the jail. It was necessary, therefore, to close the lobby. Typically, during normal times, the lobby's open. Ms. Cox's station is in the middle of the lobby, and she directs traffic. From there, allows people into the secure perimeter. From there, takes calls, takes questions from the public. Because the lobby was now closed, it was necessary to have somebody stationed at the locked door to the lobby, and you need that person to be up there close to the doorway, and that's where her office was moved to. So there was no evidence that that move was in retaliation for any of her complaints. And also, it seems unlikely that such a move would be considered adverse employment action in any event. So the third and sort of the starting point for this charge was what I'll call the memo. I don't want to say the person's name, but we'll call it the memo, which was dated October 28, 2019. The memo was presented to the leadership. They met with Ms. Cox immediately thereafter, late October of 2019. The jail administrator, major courts, and human resources manager, Amy Jennings.
No names, please.
Oh, I'm sorry, I apologize. The memo was considered, and also her complaint, of an FML status. In other words, she was concerned the confidentiality of her FML status had been spread around to people without a need to know. So they tried to drill down on the comments, who made them, what her central concern was, and she continually pointed them back to the memo. They didn't really therefore have any detail on the age comments or discriminatory behavior, and therefore acted to deal with the FML issue. They immediately issued, they directed that command staff review the FML confidentiality issues with other leadership at the jail. That was done, and the record doesn't reflect there was any recurrence of that problem. Later in January, the sheriff picked this issue up. Union representatives were also involved. And the employee asked her for additional detail on who was making these comments. She declined to provide any additional information. Nonetheless, the sheriff acted, directed senior leadership to issue a memorandum to all supervisors to make sure that during pass down, and pass down is a time when the shifts at the jail change and the people who are going off shift provide information about current circumstances in the jail to those who are coming on to the shift. The senior leaders directed that all pass down shall have a supervisor in the pass down room at the time that pass down occurs to avoid this potentially juvenile or teasing or discriminatory behavior, depending on your view of it, to make sure that that doesn't happen. And that memorandum went out on January 13th of 2020. The complainant then went on family medical leave for extended period of time until June. During that time, we have the COVID issue and the office being moved. When she came back in June, she was approached again by a senior leader to get back into this issue about age discrimination, to try to understand more about what happened. Again, she continued to rely on the memo, declined to add additional detail, said she didn't want to get anybody in trouble. And so the answer was that 2 days later, when they followed up with her on June 6th, she said, forget about it. I'm just going to file a charge with the Human Rights Commission. So she never, during these meetings, identified anyone who harassed her based on her age. And in this way, we think that there's been no hostile work environment shown. She was able to tell us that, and during the Issues and Resolutions Conference, that someone had called her grandma, or she gets called grandma from time to time. But she indicated that she did not find this offensive, depending on who said it to her. And instead, again, relied strictly on the memorandum that we've discussed. So for these reasons, we believe that the investigator did a very thorough job and got it right with respect to the three issues in this case. And we ask that the investigators' findings be affirmed and no reasonable grounds determined. Thank you.
Any questions for Mr. Bauer at this point from commissioners? Seeing none at the moment. And so then we go back to Ms. Cox. Ms. Cox, you have about 4.5 minutes left. If you want to add anything, you'd have to unmute yourself.
Okay,
There you go.
I'm sorry.
That's okay.
I'm at my husband's office and he's the technical guy, not me.
Okay, you have 4.5 minutes.
Okay, we keep referring, I go back to the memo because this could have ceased if they would have talked to the writer. And when they said they disciplined and they talked to the supervisors, there were supervisors involved. And if they would have called in the writer in an investigation, the writer would have told them exactly who were the people that were saying all this stuff. But they never once called the writer. They asked me if I would get separate statements from the 13 people who signed this. 13 people said this happens in Passtown when I am not there. So this really devastated me because I worked with these people for years. And in it, it talks about, you know, 2 of the people had been fired in this. So it tells you right now the behavior of certain people that have gone on and on and on. And back to moving me into another office, I was 1 whole year without any heat in that office. 1 whole year. I complained several times I had no heat. And no heat, no heat. Somebody gave me a plug-in heater so I could use it. I think at the beginning of the summer, they finally came in and put some heat in the office. It was very cold. It was all cinder block. So I asked and I got no results. When they said they disciplined and the administrative talked to the supervisors, they didn't talk to him very well when a lieutenant made vulgar, awful remarks to me. And that was September 17th of 2020. So this goes on after sheriff's department. They can defend themselves, whatever. We've had a total of probably 14 women who have left. So I guess I'll just let it rest at that. 14 women have left the jail in the jail department. Thank you.
Commissioners, any follow-up questions for Ms. Cox? Seeing none. Okay, thank you, Ms. Cox. Mr. Bauer, I can't remember. You have about 45 seconds left.
I don't have any further information.
Okay.
Thank you.
Thanks. Okay, so then we would go to the investigator. Alex. Yes, Alex.
Yep. Good morning, everyone. My name is Alex Brindley. I was the investigator assigned to this case. Based on what I've heard today, I don't think I have anything else that I need to add, so I'll rest on my report. But I am open to any questions if you should have any. Thank you.
Commissioners, any questions for the investigator? If so, raise your hand. I see Commissioner David. Okay, go ahead. Oh, you're muted.
Alex, in the report, and my question is, you still rely on the fact that it's not severe and pervasive, even though there's inappropriate behavior going on, correct?
Correct. Yep,
Okay.
the actions did not rise to the level of severe or pervasive.
And I think there's nothing in the report about, about the lack of heat being an intentional, action to drive her out or discriminate against her, right?
No, that wasn't
No.
included in the report.
Or no allegation to that effect.
There was, I believe it was brought up in the IRC. However, I kind of clumped that in together with the retaliation claim of moving her to a new office. It didn't seem to be any adverse employment action.
Thank you.
Any other commissioner questions for the investigator? Seeing none. Thank you, Alex.
Thanks.
So at this point, we would be looking for a motion or motions. There are 2 proposed findings.
I'll move to take them together and move that we find that there's no reasonable grounds to believe that the respondent discriminated on the basis of age or sex, and that there are no reasonable grounds to believe that the respondent retaliated and that the complaint should be dismissed.
Is there a second? Okay. So the motion is to find, to adopt the proposed recommendations for no reasonable grounds findings on all claims. It's been seconded. Is there any commissioner discussion? Seeing None. So if you're in agreement with the motion to find no reasonable grounds on all claims, answer yes to this, to my inquiry. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Dusan,
Yes.
Commissioner O'Brien.
Yes.
So the findings are all no reasonable grounds. The commission will send a letter to the parties in council confirming that, and thank you for being here today.
Thank you.
Okay, our next case, H21-0300 B and C, Patricia McNally, the State of Maine Department of Health and Human Services, and James Demmons. This is a no reasonable grounds, well, there are actually several recommendations, but we'll hear from the claimant first.
So I know Ms. McNally is here. Ms. McNally, can you unmute yourself or have someone assist you in doing that? And if you want to show yourself on the video camera. There you go. Okay, so you have 10 minutes to make your presentation. I'll just remind you not to use the names of any witnesses or people other than DHS and Mr. Demmons, okay?
I'd like to introduce myself as a disabled person, and I wanted to clarify the paperwork I have sitting around me. I am computer illiterate, so to speak, and I've only been able to do things by handwritten notes. So bear with me, but I'm trying to just do my separate little categories to bring up to the point on Mr. Demmons especially, and then adding DHS. I have, and I don't know if this is stricken from the record, if it's an agency to help me. Can I say the agency to help me if they're professional?
No, you can't.
Okay,
Thank
well,
you.
I have paperwork stipulating that I am unable. It says to determine appropriate computer technology such as Dragon, as Pat, meaning me, Patricia, cannot type with her injured hand, and it's dated for me to have services 9/2015 to end date 12/2015. I never got those services. And then after that, I have provider, which I won't name, come into my life under the main care eligibility, and it's dated 7/15/2016 to have eligibility and interprogram communication. I needed a lot of care for, it's check CI, and I'm not sure what that is. And so that was a provider less than a year later. And then I had so many medical problems up to October 8th, 2019, checked for cancer on my face, which is still there and not removed yet. And finally, I had a provider that intervened in 2018 and stipulates for this housing issue that I need, it says, this person listened to me, client, about my history and current issues with housing, and client needs assistance communicating with housing and resolving issues with her landlord when inspections fail, and advocacy for all the other things that I listed ahead of time. That provider happens to be in a level 2 now, grievance, which has never been in my life before, from a level 1 not answered many times to then this one pursued to a level 2. So that's pending currently. So I'm left with nobody at all since July. And that's the piece that I wanted to let you know about, for that specifically. The issue of knowing James Demmons and me being a tenant, if you just bear with me, I have a few notes here. I rented by Mr. Eugene Levchenko is the landlord.
Nope, we can't use names, sorry.
Oh, I'm sorry. He's my landlord, and I rented from him in the year 2007. I only rented for a full year, and I paid him cash for my Social Security check. I didn't have any Section 8. I was on hold waiting. I received that in 2008. So for 2007, it went fine with my landlord and myself, and it was just a very small mobile home, and I had to pay extra money for my belongings in a storage unit. I finally did get into my new apartment under Section 8 and resided there from 2008, in March 2008, up until when I gave my 30-day notice to move to 45 Oak Street in 2016, to which December 15th was my deadline. It surpassed into January 13th with a new provider that did not help me make my deadline, but nonetheless, I lived for 8 years on Section 8 the first time I got it, and was still friends with the landlord all those years. And I witnessed them having other renters, and there seemed to be 5 different renters that would only have the barter system. And then at any given time, which I witnessed, they could call the police and have the people kicked out at that moment. And they did that. And they were friends from a distant past, and they had to walk out of the building at 8 at night with backpacks on. I called the not 911, but emergency crisis. It was up in Munjoy Hill. They told me after, and I talked to a professional counselor. What do I do after this had happened and the people had to walk away and leave their bedroom set for their daughter who was transferring to a school? It was a big all set up thing, but there was no contract. So James Demmons comes into the picture as a friend, as a son of the landlord, and he walked me around the house while somebody sat in the car waiting because he didn't have a car. And he told me he was going to unlock the bathroom window, so when the person got sick, when the people got tired of walking around, that they could climb back in. And he said, but just don't tell. It happened to be his dad, the landlord. And so they drove off. I called emergency help. Then I drove to a public official that's also a psychiatrist that I wrote notes and put him in the mailbox. And eventually, after 3 or 4 weeks, I called him and he answered. He said he won't help me because he had no time. And I only really wanted the Brunswick location at 2007 for that year because I had to get to my medical. And I went to Parkview, and I have a little poster thing, take me to Parkview, a bumper sticker. So I'd been working on all my medical at that point. After this, it seemed very unusual way of doing business with renters. There were multiple people. So I was safe in my own apartment on Section 8. And then in 2013, my friend we carpooled together a lot, and my hand has a problem. So anytime I can have a ride and relax in the passenger seat and do my work and look out the window is a welcoming thing for me. So the man, my landlord, drove me around. We remained friends, even though I moved to Section 8 and he wasn't my landlord at that time. He had a one night almost near death experience with a fender bender, and he was rushed to emergency ER, and they said he's had a dying night. He had cancer diagnosis, and he had waited for an out-of-state referral coming up in 3 weeks. And that's the phone call he got when he had the fender bender, and I was in the car with him. And the police and everybody saw me with my mask on because I'm missing teeth that haven't been replaced properly. I've been wearing a mask since that year, all that time, all the way before COVID. I've had to wear a mask everywhere I go in the world. But anyway, the landlord person that had this told to him, I stuck by his side, and we went up to he had the emergency operation in Portland. I was the only one in the hospital. There was no James Demmons, who is his biological son. There were no children. There wasn't even a doctor visit. When I came to get him a week after, he was fine, came out of the hospital, the cancer had been removed, they rechecked it. I took him back to my apartment to care for him, drive his car, and I did the things that, in my opinion, clearly show guardianship and conservatorship definitions that I've written when you care for somebody. And I didn't pay any money, ask for any money, it was friendship. And then I threw in the towel at the end of 2016 and said, I will move to the first floor, 45 Oak Street Garden. It's a house. It's not on the second floor elevator with my storage still packed somewhere else in a little efficiency apartment on Section 8. If this could be approved, I would love to live there. So I get there, and the Maine State Housing was attached immediately. They did a walkthrough, and I had my paper in front of me, and it was failed the first time. And James Demmons put his name on it as a property manager, and it was dated to me September 6, 2017. And then the second paper, September 14th, says this unit failed this reinspection. And then the last inspection was It's dated March 4th, 2020, and they were coming back March 31st, 2020, but we had COVID and they never came back ever. And so I left here with a 2-page, it's all for owner of responsibility for the failures in the inspection that James Demons had wrote on his paperwork and the lease that he was the property manager and he would do these things, which he failed to do. Furthermore, he put a letter into the mail, a notice to quit that I have here, dated 3/2/20, sent it directly to the main housing, and my landlord and I had no knowledge of this, living at 45 Oak Street. And since 2017, it said it was a notice to quit. The reason the notice is issued for management transition, vacant property needed for the renovations, which lines up with those lists, the 2 pages of the things that does not need me to leave. I can so quick go down the list so you have a better idea. It says that the electrical hazards out with behind a couch, no power. It says there's a storage room off the living room. The ceiling is damaged, which only lists things in front of me. That would be one that stands out because it just broke through on January 9th. The ceiling caved in with water. James Demons left upstairs screens open, the windows open, and all the blizzard we had in the beginning of January triggered the water in the bathroom. It came through this ceiling that was already listed that needed to be patched up. It was only taped up.
Ms. McNally?
Yeah.
I'm sorry to interrupt you, but that's actually the end of your time.
My time is over. Well, okay, can I
Yeah.
come back?
No.
Mute
So
me?
here's what's going to happen next. Next, I'm going to ask our commissioners if they have any questions for you. If they don't have any questions for you, then you're done being able to present. And then we'll go and hear from the respondents. Okay, so commissioners, are there any questions? Do any commissioners have questions for Ms. McNally at this time? I do not see that any of the commissioners have questions for you. So I'm going, that's the last time we will hear from you. Next, we'll hear from the respondents and then we'll hear from the investigators. So for now, I'm going to mute you, but you can still listen and observe what's happening.
Could we, Amy, could I ask you one thing?
Yes.
The notice to quit never
Nope,
went.
we're all done.
Didn't go through for the housing?
Nope, so I'm not your lawyer. I can't talk to you about your house.
I didn't have that stopped my lease.
Ma'am, I cannot help you with your lease or
No,
any
there
notices
isn't
you
one.
get.
It stopped by them stopping the subsidies.
Ms. McNally.
Okay.
That's the
I'll
end of
just
your
wait.
time.
All right, I have all these papers
You
around
don't
me.
have to leave. You can just
Oh.
listen.
Okay.
Okay. Okay, then we will turn to respondents. Ms. Morrill, I know you're here for DHHS. Do you represent Mr. Demons as well?
No, I don't.
Okay, so after you're finished, we will see if he is here.
Okay, thank you, Amy. Good morning, commissioners. My name is Kelly Morrill and I represent the Department of Health and Human Services. The department's involvement in this case has been very limited. The complainant was a tenant in a 2-unit residence owned by the landlord in this case in Gardner. The department's Adult Protective Services division became involved with the landlord in 2020. The probate court has also been involved with this case. In early 2021, the probate court issued a temporary guardianship order to the landlord's children. Because the department was involved in that at that time, and I believe there may have been a challenge to the guardianship at that point, the court appointed the department as the emergency temporary guardian of the landlord in late February of 2021. Then in April of 2021, acting as the landlord's temporary guardian, the department served the complainant in this case with a 45-day notice to quit the premises in Gardner so that it could be sold for the benefit of the landlord. The parties went back to probate court following that, and in May of 2021, the department, by agreement, was removed as the temporary guardian of the landlord, and the landlord's children were made guardians of him. So at that point, the department sent the notice to quit that it had served on the complainant to the attorney for the new guardians, the landlord's children, and they took over with whatever eviction proceedings were going on. So that is the extent of the department's involvement here with the landlord and the complainant. I mean, some other things happened in between, but I think the relevant parts of this have to do, because this is a housing case, the relevant parts of this have to do with the service of the notice to quit and the subsequent eviction proceedings. But the only involvement the department had with that was just the service of the 45-day notice. And then the department got out as soon as the permanent guardians were appointed here. So that's all I really have. I'm happy to answer any questions that the commissioners might have at this point.
Thank you. Commissioners, I see you, Commissioner Ashby. Any questions? I see. Okay, let's start with Commissioner Ashby and then Commissioner David.
Hi, just very quickly, the notice to quit was it was a no cause notice to quit to terminate a tenancy at will. Is that correct?
Yes.
Thank you.
Commissioner David?
And that notice to quit is certainly an adverse action to the tenant, is it not?
I don't believe at that point it was an adverse action because there wasn't any action taken. It was just a notice to quit. The department didn't follow through. I don't think at that point.
Okay, I think we disagree as to whether giving somebody a notice saying get out is not any action because you weren't around to pursue it. My other question is, you say as though it's obviously a justification that they just wanted to sell the property. Did you make any investigation as to whether the ward would have wanted that to happen? I mean, as I understand this, the most essential thing here is the relationship of the complainant to the landlord in terms of mutual help and what he would have wanted. And it seems to me that you're saying, you correct me if I'm wrong, the department doesn't care. He's our ward. We're going to sell it for his benefit, whether he would have wanted the benefit or not, or for
Before
the
you
children's
answer,
benefit.
oh, I'm sorry, I didn't mean to cut you off. I just wanted to say, please limit your answer to what is in the record here, because I don't believe there's a lot on that point.
Well, that's my question. Is there any investigation made by the department?
Well, at that point, the department was the emergency temporary guardian. So the department was charged at that point for doing what was in the best interest of the landlord. So they are making the decisions on his behalf, and determining what is in his best interests. And I can tell you during this whole thing as well, the complainant in this case was interfering with the guardianship and with the department's authority with respect to the landlord. I believe that is in the record, to the point where law enforcement had to be called because she was picking him up. He was taken out of the Gardner residence at one point and brought to a place in Brunswick, and she had picked him up at one point and brought him back to Gardner without the approval of the department. So the department was doing its best in this case as the temporary guardian to do what was in the landlord's best interests. And part of that was to sell the residence in Gardner because he was no longer living there, so that the proceeds could be used for the ward.
Commissioner David, and you all set on that? Okay. Any other questions for Ms. Morrill at this time from commissioners? Seeing none. Thank you, Ms. Morrill. Is there anyone here for James Demons? I have not seen his name on the attendee list. And he did get notice because I mailed it to him myself. Okay, seeing none. Ms. Morrill, you have about 7 minutes left if you want to use them.
No, thank you. I'm happy to answer any other questions.
Any last questions for Ms. Morrill from commissioners? Seeing none. Okay, thank you. At this time, we would go to the investigator, Kit Thompson-Crossman.
Morning again. My name is Kit Thompson-Crossman. I was the investigator assigned to this case. I don't think that I have anything to add right now. I'm happy to answer any questions. I will say, as it says in the report, Mr. Demmons has not participated in this investigation at all, despite multiple invitations to do so.
Questions? I see Commissioner Ashby.
I kept picking up where Commissioner David left off. I'm challenged by your finding that that if the respondent DHHS knew of the complainant's disability, they nonetheless aren't liable because the notice to quit wasn't an adverse act. Is that really your position?
The standard is that the respondent refused to permit complainant to continue to rent the apartment, not an adverse act. And they took.
Fair enough. I understand the distinction, but a notice to quit terminates a tenancy, right? Your tenancy is hereby terminated.
It notifies a tenant that the landlord intends to terminate the tenancy through a court proceeding. Plenty of notices to quit don't go anywhere, and the tenancy continues. And in this case, the tenancy did continue. She was never served with an eviction. She was never, she was told that they intended to terminate her tenancy, but they did not, in fact, do that.
Okay. Secondly, I guess I'm really at a loss as to what the discrimination was in this case as to the landlord Demmons. I understand, as I understand the facts that you've developed, it was a no cause notice to quit in a tenancy at will. And if cause, in fact, it became known to us, the only cause that we became aware of was the desire on the part of the landlord to sell the property on behalf of his father, as I understand it. Is there any evidence in the case of discriminatory animus at all?
So with respect to respondent DHHS, the motivation for sending the notice to quit was their intent to sell the property in order to benefit the landlord. With respect to Mr. Demmons, we have no evidence other than the notices to quit that we've seen of why he wanted to evict her. We don't have any, he has not participated at all. And as you know, our standard is even chance, and she has met her prima facie case against him, and he has provided no evidence to the contrary. It's clear that he knows that she has a disability. He's known her for several years. He knows why she receives her housing voucher. He's had a personal relationship, certainly not a friendly one, but he's known her for several years. He knows that she's disabled. He knows that she could continue to rent the premises. And he has nonetheless refused to, he's taken her to court on this several times, as opposed to DHHS, which never did.
Do you establish your prima facie case though by simply taking the act? Don't you need something more? I mean, I'm not sure she's established her prima facie case. She's disabled and she's being evicted. Well, you're allowed under the law to evict disabled people.
So the prima facie case for eviction in this circumstance is just that she's a member of a protected class. Respondent Demmons, in this case, is aware that she's a member of that protected class at the time that he's trying to evict her. She's willing and qualified to continue to rent the apartment, which she is, and that he has refused to permit her to continue to rent the apartment, which he has. That's the prima facie case in this circumstance. There isn't, intent is not part of it right now. If he had come back and said, no, I'm actually evicting her for XYZ reason, then she has to prove that that reason isn't legitimate, but he hasn't done that here.
Well, the same notice to quit was simply handed off because of the authority changed from the Department of Human Services to this guardian. The same notice to quit was handed off to this landlord, and we can
not just that one
reason. And if we don't infer that reason, then we aren't allowed to infer any reason. The notice to quit with no cause is by definition non-discriminatory.
Sorry, I didn't mean to interrupt you. I thought you were.
I interrupt people all the time, so don't worry about
it. That one notice to quit did get passed off to her. That's true, from DHHS. That got passed on to Mr. Demmons as the landlord's guardian. There have since been others. You're right that there's still no reason given, but at this point, she doesn't have to prove his intent. She just has to prove that she has a disability. He knows she has a disability, and he's refusing to let her continue. The difference between Demons and DHHS is that DHHS never actually took any action besides the notice to quit to evict her. They never took her to court. They never served her with papers, like the writ of, I don't know what it is here, but they never served her with anything actually making her get out of the apartment. He's taken her to court 2 or 3 times pretty recently, as far as I know, and hasn't provided me with any evidence that it's not because of her disability, hasn't provided me with any evidence as to why he's evicting her at all. And at this point in the case, that's not part of the analysis. I know it seems a little, it does feel a little counterintuitive, but
it's not counterintuitive to me. I'm inferring the landlord's reason for wanting to evict. It's the exact same reason as was actually expressly stated by the Department of Health and Human Services. But I'll leave it at that.
That's not in the record. Jeff.
His intent is not, I've got nothing.
No, I'm inferring it from facts that are in the record.
And our even chance standard, I think at this point means that she's made her case, and he hasn't provided me with anything to rebut it.
Any other questions for the investigator, Commissioner David?
This is Kit, this is a 2-unit residence, the landlord and the tenant?
As far as I understand it, two floors.
And when DHHS gets the emergency guardianship, well, obviously it's a guardianship, he's alive, correct?
Yes, correct.
And you unquestionably, that's the challenge. You unquestionably say that, well, they can say we want to sell it, and so they have a right to do that, whether he wants to or not. I mean, I've seen these cases before. DHHS says, oh, we have the right to decide, and we want him to have the money. And then you see what happens to the money after it's in DHHS conservatorship. But why don't they have a right to investigate what he would want? He has a relationship with her, one of mutual dependence.
I mean, the only thing I can say is that isn't in the record. I will say that guardianship, the temporary guardianship that Attorney Morrill referenced, was very brief. It was a matter of maybe 8 weeks. It was in the pandemic. There was lots of stuff going on, but that's not in the record, how much investigation they did, what his capacity was for making a decision, any of that.
I agree. It was very brief. They just perfunctorily say, he owns real estate, we're going to sell it. I mean, I think the DHHS discriminates against the tenant who has a disability. But I'll say
the landlord wasn't the landlord was not the tenant in that case. But I mean, I think if we had gone further in the legal analysis, DHHS had provided a reason for why they wanted to sell the building, why they wanted to end complainant's tenancy, and it didn't have anything to do with her disability.
All right. And I still think when you give a disabled, especially a disabled person that's relying on that tenancy that's been there for 8 years, a notice that says your tenancy is terminated, you're out of here in 45 days, that's an adverse action. And that it's agree. Okay.
I don't disagree that would be an adverse action. The analysis here is not whether it was an adverse action. The analysis is whether they refused to allow her to continue to rent the premises. And DHHS, besides that notice, took no action to stop her from renting the premises, and in fact, never ended her tenancy.
Thank you.
Any other questions from commissioners for the investigator? Seeing none. Thank you, Kit. So we've heard from the parties and the investigator. So now we would be looking for a motion or motions. There are 3 proposed findings.
I'll move that there are no reasonable grounds to believe that the State of Maine Department of Human Services discriminated against the complainant on the basis of disability or retaliated against her. And those claims should be dismissed in accordance with the act.
Is there a second?
I would second it.
Thank you. So it's been moved and seconded. Is there any discussion among commissioners? This is regarding DHHS.
Yeah, I think they discriminated. I think they acted hastily without investigation and just trampled the fact that there was a disabled person that had a relationship with the landlord because of their bureaucratic decision to we want to sell his premises. So I'm going to vote against the motion. I don't think I'm concerned about the fact. I don't think they retaliated, but I think they discriminated on the basis of disability. But I don't think we need to take them separately because I think I know where the action's going.
Interestingly, I concur with you, Commissioner David, on the position that giving someone a notice to quit is denying someone housing. It terminates a tenancy. If I had sent someone a notice to quit that said, you're an African-American, and as a result, I'm going to evict you, I assure you that that's actionable. I just don't believe that the Department of Human Services in this case evicted on the basis of disability. That's all. I don't think they did so at all. They expressly stated the reason why. Even if they didn't, they're allowed to evict a disabled person for no cause. They happen to have a cause, so they can rebut any suggestion that there no cause notice to quit is pretextual, but it doesn't matter. And with all due respect, I guess I suggest that I buy the department's argument that they are required to act in the best interests of the ward, not as the ward would want them to act.
That's true, and that's demeaning and condescending to the ward. But that's
maybe. But if the ward wanted Charles Manson to take care of him, for example, instead of a qualified nurse, for example, the department should be able to say your wishes are not.
Exactly, and that takes a detailed investigation and an interview with the ward, and the court appoints people to go and make those independent recommendations. I've been appointed to do it.
Sure, but that analysis isn't necessary in a case where that's a no-cause eviction. All right. Anyway.
Any other discussion from commissioners on the pending motion?
I want to make one thing very clear, by the way. I did not mean to equate our complainant with Charles Manson at all. I want you to make sure you hear me say that. I was using the most extreme, absurdist example I could use. That has nothing to do with you, ma'am.
So the pending motion is to find no reasonable grounds to believe that the state of Maine DHHS discriminated or retaliated against Ms. McNally. If you say yes, you're in agreement with that no reasonable grounds finding. Commissioner Whitworth. Nope, couldn't hear you.
Yes.
Thank you. Commissioner Ashby?
Yes.
Commissioner David?
No.
Commissioner Doosan?
Yes.
Commissioner O'Brien?
Yes.
So the finding with respect to DHHS is no reasonable grounds, but we still have two other proposed findings.
I'll move there are no reasonable grounds to believe that respondent Demons retaliated against complainant for engaging in the protected activity, and that claim should be dismissed in accordance with the act.
Second that.
So any discussion among commissioners of that pending motion? Seeing none. So if you, the motion is to find no reasonable grounds to believe that Mr. Demons retaliated against Ms. McNally for engaging in protected activity. If you say yes, you're in agreement with that finding. Commissioner Whitworth?
Yes.
Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner Doosan?
Yes.
Commissioner O'Brien?
Yes.
So that is a no reasonable grounds finding.
I'll move that there are no reasonable grounds to believe that respondent Demons discriminated against the complainant on the basis of disability, and that claim should be dismissed in accordance with the act.
Second,
So that has been moved and seconded. Is there any discussion among commissioners? Yes. Commissioner David?
Yeah, I mean, I'm concerned about this business that you can give a 45-day no grounds notice because you want your premises back and you want to sell them. Doesn't that depend on a factual analysis as to whether you continue to rent them to other people, as to whether isn't that bear on the decision as to whether it's discriminatory against the tenant that's already there that has disability, that you just want her out? I mean, how do you make that distinction? Or are you saying there's no distinction to be made? He has a right to sell the premises, whether she's disabled and whether he's going to rent them to somebody else or not. Often the ruse is you give a no grounds eviction, you do some renovation, and then raise the rent and rent them to somebody else, right?
Well, I think it's an evidence-driven thing. I mean, if there was evidence in this case that the guardian of this ward represented that they prefer to sell the property and not rent it out anymore to any other person, and then 3 days after the eviction, rent it out to another person, then you'd be able to argue that their reasons were pretextual. But there's no such evidence in this case.
Do we know what happened?
I don't know that we have to find out what happened. And if we don't know what happened, there's the absence of evidence isn't evidence.
Any other discussion among commissioners? Seeing none. The motion is to find no reasonable grounds to believe that James Simmons discriminated against Ms. McNally on the basis of disability. If you say yes, you're in agreement. Commissioner Whitworth,
yes.
Commissioner Ashby,
Yes.
Commissioner David,
No.
Commissioner Doosan,
Yes.
Commissioner O'Brien.
Yes.
So that finding is, all three findings are that there is no reasonable grounds to believe that unlawful discrimination or retaliation occurred. The commission will send the parties and council a letter confirming that, and thank you very much for being here. So next, Deb, you're muted.
Gosh, I went through all of that. So our next case, H21-0364-A and B, Jason Hansen v. Clovis, Nayakurimu, I'm sorry, I did not do well with that name, Nayakurmi and Michaeling Najimbri. Is there, it's a reasonable grounds recommendation. Is there anybody here for the respondent?
Yes,
Before
Elliot
we-
Epstein.
Thank you. Before we start, the commission was told that the respondents would have an interpreter of their choice. We offered to hire an interpreter. Oh, is that the interpreter there? Okay, I sent multiple messages to Mr. Niyakuri and his attorney asking if there was an interpreter here and nobody responded. Can you give us your name, sir? After you unmute. First, you have to unmute.
Yeah, now can you hear me?
Yeah, I can. Yes. What's your name?
Yeah, my first name is Philemon, which is Philemon, and my last name is D as dog, USHIMIRE.
I'm sorry, my brain cramped after the DUSHI.
MIR as Robert, E as elephant.
Okay, Dushamir, I'm sure I pronounced that wrong.
Yeah, that's my name.
Okay, thank you very much. So we're going to hear first from the respondents, and I'll just note that I think this interpreting cannot happen at the same time, we'll need to add some extra time in to allow for interpreting.
Yes, thank you.
So the respondents have 10 minutes. Is Mr. Niyakuri presenting or Mr. Epstein or both?
I will present.
Okay. So you'll have, I'm going to start with saying you have 10 minutes unless it seems as though we need additional time. And Mr. Dushamir, if you need us to pause, can you let us know for the interpreting process?
Yes, I will.
Okay.
Thank you. My name is Elliot Epstein, and I represent Clovis Niukuri and Micheline Najambert, the respondents. I've raised 3 issues in my objections to the investigator's report, and those are the 3 that I want to discuss with you today. The first, and probably the most consequential, is the burden of proof or standard of proof or standard of persuasion that the investigator used in reaching her findings. Her standard, the one that she articulated in her report, was that there was at least an even chance that there were reasonable grounds to believe discrimination had occurred.
Can I ask you to
Now-
pause for a second? Thank you. I need you to give me a really clear sign when you want us to pause.
Okay, good. Thank you. So I will try to just to summarize quickly what I mean, to interpret quickly
Yes.
what the attorney just saying for them.
Yep.
Avuze yuko ubunye ari waza gupresenta kangene meze kandi akavuga yuko ahakana ibintu byashikirijwe n'abagize amatohoza, ingingo bashitseko ko n'ingingo bafashe baterekanye preuve n'imwe. Yes. Go ahead.
Just so you know, Mr. Epstein, I'm only timing you and I'm stopping when we're interpreting. So you get 10 minutes.
At least an even chance is essentially a 50-50 standard. Now, the burden of persuasion, burden of proof, is a very powerful tool both in litigating cases and in deciding cases.
Can you pause
In
for a
Maine-
second? Can you pause for a minute?
Avuze yuko ngo ivyo abatohoje batoye wewe warabihakana kuko mu bisanzwe kugira ngo ufate ingingo utegerezwa kwerekana neza yuko watohoje cyangwa wagendereje amapreuve yose yatanzwe. Uravuga ati kuri jewe nta ibyo bavuze yose babivuze ata preuve batanze bafatiye kugira ngo izo ngingo zifatwe. Go ahead, sir.
In Maine, there are essentially 3 standards that are used. Proof beyond a reasonable doubt in criminal cases, proof to a high probability, clear and convincing evidence in certain specialized kinds of civil cases, such as reformation of deeds or fraud, and the standard that is used in almost all civil cases, including cases decided by under the Maine Human Rights Act, and that's the more probable than not or preponderance of the evidence standard.
Here you go, sir.
Oh, yes, pause.
Avuze yuko muri mategeko muri Maine hari ibintu bitatu bikomeye, hari uburyo butatu bukomeye bwo kwerekana yuko ibintu byabaye. Ati nk'iyo ari nko mu manza zerekeye ibyaha, ni ukwerekana yuko iyo preuve uzanye ari preuve ya mbere ikomeye ishoboka kuboneka muri izi rubanza. Hanyuma iyo ari bijyanye n'imanza z'amatati, naho urerekana neza yuko iyo preuve uzanye ari preuve yabaye wanashaka yabaye yavuzwa ko n'abantu bose n'impande zose zikayemeranya. Iya gatatu nayo ni uko mu zindi manza zose zishoboka n'imanza ziza imbere y'iyi komisiyo turi kumwe uno munsi, ni ukwerekana yuko ivyo uko yabivuze mu Congereza ni preuve iboneka ko ni preuve izerekana yuko ivyo bintu byafashe igihe gikwiye biba kugira ngo ntihagire umwe ashobora kubihakana ko byabaye. Go ahead, sir.
Thank you. Ultimately, if the complainant in this case were to go forward to court, he would have to satisfy the judge or perhaps the jury by a preponderance of the evidence, or more likely than not, he could not use at least an even chance as the standard.
Nk'uko mubibona uko urubanza rumeze uno munsi bikenewe ashobora kuzorutwara imbere y'umucamanza kugira ngo berekane neza ko ibintu ariko aravuga vyabaye kuko nabivuze imbere imanza zose zibashaka muri main tuza kwerekana preuve igituma canke preuve yerekana ko ibintu ariko aravuga byafashe igihe gikwiye biba kugira ngo ntagire ushobora kubihakana.
So it makes more sense at this stage to ask whether there are reasonable grounds to believe that the complainant could meet that burden at the next stage of this case.
Aho tugeze cyangwa ko nabibona ni uko hobazwa ikibazo kibazo gikomeye ni uko uyu muntu yitwaye ku by'ukuri ibyo yavuze arabifitiye ibyemezo bikwiye canke preuve zikwiye ko byaba kugira ngo wanashaka duze tuvuge yuko ibyo yagiriza mu bantu bifise n'ishingiro. Go ahead, sir.
Thank you. Under federal law, the Equal Opportunities Commission makes similar findings to the Maine Human Rights Commission. The only difference is that under federal law, the EEOC decides whether there are reasonable grounds to believe discrimination has occurred. Under state law, we decide whether under federal law, they decide whether there's reasonable cause, and under state law, whether there's reasonable grounds to believe that discrimination has occurred.
Pause, please. Yeah.
Pause, please. So, kuravuga ati musangene bimeze amategeko ari ku rwego rw'igihugu asaba yuko haba ko herekanwa yuko hari bituma dushobora kwemera yuko uko kurenganya umuntu canke uko kuvangura umuntu discrimination mu Faransa byabaye, ariko mu mategeko nayo ya leta turimo leta men turimo asaba yuko twerekana yuko hoba hari igituma gifadika dushobora gufatira ko mu kuvuga yuko abo bantu barenganije mu canke bamo discriminating. Go ahead, sir.
Thank you. That really is just a difference of wording. I don't think it's a difference of standard. The Maine Law Court, our state Supreme Court, has held that cases under the Maine Human Rights Act should be interpreted consistently with analogous federal discrimination statutes.
Pause, please. Uko ndabivuga ndabisigura urwego rw'igihugu national cyangwa ibihugu ku rwego rwa leta ya Maine, twumvane n'amajambo gusa atandukana mugabo by'ukuri haba sentare nanyuzwa ko supreme y'iwacu muri Maine ivuga yuko kugira ngo umuntu yemeze ko habaye kurenganya umuntu cyangwa kudiscriminate umuntu ategezwa kwerekana igituma kwerekana preuve zerekana ko icyo kintu cyabaye umwanya muremure ku buryo atamadidani menshi ashobora kuba kuri icyo kintu. Go ahead, sir.
Thank you. And under the Equal Opportunities Commission guidance, that's exactly what federal investigators must do. They must apply a preponderance of the evidence standard. So it would seem to be consistent with federal law and practice that this commission should be applying the same standard.
Can you pause?
Yeah. Kugira ngo dufatiye ku mategeko novuga nti amategeko anganisha abantu bose ko abantu bose bangana equite mu Faransa ni navyo wanashaka leta ya Amerika ku rwego rwo hejuru inasaba amaleta ari muri leta zunze ubumwe za Amerika yuko yokurikiza harimo n'iyi komisiyo uno munsi kiratwumviriza komisiyo ije kweza hagati muntu muri leta ya Maine yuko kugira ngo yemeze ko ikintu cabaye iteza kwerekana neza yuko ifise preuve yuko ivyo bintu vyabaye umwanya muremure ushoboka ukwiye ku buryo atamadidane aba muri ivyo bikorwa. Wahetse.
As a practical matter, in a case like this, where you have two parties giving diametrically opposed accounts of conversations that took place between them, credibility is all important. And judging who is more credible is very important. So if you
rero ko jenda yibona muri urubanza dufise hano aho bari abantu babiri bose bafatira ku byo bavuze ku byo baganiriye umwe avuga ati navuze ibi undi navuze ibi kugira ngo hagire uwo twemera kugira ngo hagire uwemerwa kugira ko aravuga ari byo byari bikwiye rwose yuko byiko ndavuga byo kuvuga yuko umuntu wese ibyo avuga azana igituma cyerekana ko ibyo bintu byabaye umwanya ukwiye umwanya muremure kugira ngo impari ziri hagati z'uyu n'ubundi zigabanuke. Gohetse.
So if you use a 50-50 standard when trying to assess the credibility of evidence or the credibility of witnesses, it becomes like a coin toss. And as you know, if you toss a coin 100 times, it's going to come up heads 50% of the time and tails 50% of the time. In effect, it's like having no standard of proof at all.
Can you pause for a minute?
Yeah. Ati rero ndaje ku rubanza rumeze. Ati tuvuze yuko tugende kuvuga yuko ngo hariho ibice 50, umwase ibice 50, ibice 50. Nta cemezo kandi nta rubanza rwo turaca ku by'ukuri tene nko gufata ikingoro ngo ukagitera hejuru biteye hejuru hamwe kigwa cuburuye handi yabacuba tiragoye kuvuga ko twofata ibyo bintu tukabiha agaciro yuko rero twofatira ko twofatira nk'icabona nka preuve muri no rubanza turimo. Go ahead.
Thank you. Perhaps because the standard was applied, the investigator presented the evidence, presented the account of each side as to what was said on 4 different occasions, but didn't really try to assess, weigh, evaluate, or analyze the quality of the evidence or the credibility of the evidence.
Pose. Ati urubanza rwo ndabibona umuntu wese uwakoze amatohoza muri rubanza yumvije uruhande rumwe yumviriza n'urundi agerageza nko kusa n'uhuza ibintu cyangwa kumva ibintu kwa byumva mugabo ntiyigeze ku by'ukuri ashika guca amategeko asaba kurondera yuko haba preuve kurondera ko haba icemeze no kurondera mu kirundi kimwe kidasubirirwa cyangwa kidasubirwamo kugira ngo dushobore kwemera yuko ivyo yakoze yabikoze ku rugero rushimishije gufasha amategeko yo muri leta ya Maine. Go ahead, sir.
I have given a number of examples of things that should have been weighed or evaluated in terms of judging the evidence in my written submission. I'm not going to go.
Yeah,
I'm not going to go over those in detail.
Can you pause for a minute?
Okay, pause. But jewe nakoze naranditse naraberetse uko jewe ndavyumva ibintu byategerezwa gufatirwa cyangwa byatezwa kurabwa kugira ngo hagire ingingo yose ifatwa muri no rubanza. Ati singiye gusubiramo ivyo navuze ko naravyanditse narabibandikiye murabifise. Go ahead, sir.
Just as some examples of the 4 different conversations or confrontations that allegedly took place between the parties, two of them in June and one in August of 2021, Mr. Hansen never mentioned in his complaint or his subsequent written submissions or his protection from harassment complaint that there was anyone else present at those or anyone else who witnessed those.
Can you pause for a second?
ati mfatiye nk'ibyo dufise nk'akarori mfatiye ibyo dufise hano dufatiye ku majambo canke ku biganiro vyakozwe hagati y'abantu baburana nta na hamwe uretse yerekana neza ufatiye ku biganiro vyakozwe mu kwezi kwa gatandatu canke mu kwezi k'umunani nta na hamwe uyu yitwarira aba bantu yerekana yigera avuga yuko aba bantu bamurengeye akarimbi canke bamurenganije canke bageze ikintu kimwe bamugirira adashimye kugeza ico gihe nta ntamwe vyerekana bivuga kugira ngo dushobore kubifatirako canke tubifate nk'uko yoba ari icemezo gifadika cumvikana cemerwa. Go ahead, sir.
He first mentioned in his interview with the investigator that an unnamed friend witnessed these three episodes.
Pause. ntiyigeze yerekana ntiyigeze atanga igituma gifadika kandi wanashaka n'uwo yavuze yuko ari cabona ciwe umugenzi wiwe. Go ahead, sir.
And then on the last day for submission of evidence and written materials, he produced an affidavit from this friend who we know from his protection from harassment complaint was his best friend. All of these things should have been considered in assessing both Mr. Hansen's credibility and the credibility of his friend's affidavit.
Can you
Pause for a minute?
Yeah. Ariko kuvuga ati gushika umunsi wanye turungikirako ibirego canke ibiza kurungikira iyi komisiyo. Uyu muntu avuga ko yitwara nta kindi kintu yari bwigere avuga kiretse yuko yazanye avuga canke yerekana kugira ashimikire canke ashigikirire avuga ko vyabaye kiretse témoignage imwe yarungitse mu munsi wa nyuma turungikije ibintu naho nyene témoignage y'umuntu tuzi neza hano ko ari umugenzi wiwe ati rero twari dukwiye kubiraba neza kugira ngo dushobore no guha agaciro iyo témoignage y'uwo muntu. Go ahead, sir.
There were two other incidents, one allegedly a phone conversation and the other allegedly a confrontation at a grocery store, which would have involved other disinterested witnesses who were not parties to this case and who were not friends of Mr. Hansen.
Pause. Ibintu ariko aravuga hano canke ibintu yabagije avuga ibintu bibiri avuga yuko rimwe yari conversation kuri telefone aho mushobora kuba avuga ati bashobora kuba barabwiye nabi canke ibintu nk'ibi ati bigira kabiri akavuga yuko akavuga ko hari ikindi cyoba carabereye muri magaza akavuga yuko abantu bashatse kumwagresa ati mugabo ivyo byose ntawe ushobora kubiha agaciro mu gihe icabona conyene ari umugenzi wiwe kandi hari gushobora kuzamwo abandi bantu kumbere bo vyabona batagira ico bapfana na kimwe n'aba bantu babiri bariko baraburana. Go ahead, sir.
No such evidence was presented to the commission.
Izo nizo preuve canke ivyemezo vyahawe ino komisiyo by'uko iriko twumviza uno munsi. Go ahead, sir.
Perhaps the closest thing we have to objective evidence in this case is a series of texts between Mr. Hansen and Mr. Niyokuri extending over several months.
Ico dufise kumbure twovuga tuti kiraho n'icemezo kiboneka umuntu ashobora no kuraba akavuga n'agaciro gatoyi n'agaciro ni message text message yabaye hagati ya Niyukuri n'uyu muntu ariko aramubona. Go ahead, sir.
Those texts were mentioned by the investigator, but not considered in assessing the evidence. They're important for two reasons. First, Mr. Nyakuri, in tone and in content, is calm and businesslike in his communications. There is no threats, no aggressive approach. It's very different from what Mr. Hansen describes in their personal encounters.
hose ati iyo pera ndavuga rero iyo text message niyo umuntu yagize amatohoza yafatiye ko atari kwiravye ku by'ukuri nta kintu na kimwe ubona kirimo aho bavuga ati niyo ukuri ndavuga nti yararengeye akarimbi yaratoteje yaragesheje uyu muntu ariko aramuburanya iyo niyo preuve umuntu yagize amatohoza yatanze ariko biravye ku by'ukuri nta kintu na kimwe kuri jewe gifadika kirimo wovuga ngo kiragiriza uyu muntu niyo kuri yuko yamurengeye akarimbi canke yamutoteje canke yareze amategeko mu ruhande rwiwe. Go ahead, sir.
Mr. Hansen's text contained no hint of the fear that he says he felt or the sense of indignation or outrage that one would have expected from him if he had been confronted, as he says, by Mr. Nyakuri.
Hose ati usomye ibyo niko ndavuga iyo text message bafatiyeko kandi bamwibyo bintu byose nta namwe by'ukuri ubona ko hari iterabwoba ririmo kuri uyu muntu Hansen ntabona ko hari iterabwoba kiba yavuye kuri niyo kuri ririmo kandi aribyo bafatiyeko namba ku by'ukuri yarigeze atera ubwoba ati ufashe naho nyene nahavuga yuko hava ko bahuriye muri iduka muri store naho nyene ku by'ukuri nta cemeza gihari ko uyu muntu yateye ubwoba. Go ahead, sir.
And finally, the use of these allegations in terms of providing a defense to a potential eviction, as well as the protection from harassment complaint, which also provided a potential defense to an eviction, should be considered in assessing Mr. Hansen's credibility.
Hose ati rero kuri jewe ufatiye kuri ibi yavuze kugira ngo ufatiye kuri yavuze haba ku kigo cyo kuvuga ko bamukuye mu nzu haba ku kigo ashaka kuvuga yuko yoronka amategeko yoronka uburyo bwo kumukingira ibyo bita protection order hano ati mubifatiye ko dusanga ku by'ukuri atana kimwe cerekana yuko atana kimwe kitwe atakintu kimwe cerekana ku by'ukuri yuko ibi bintu bikomeye ku buryo byofatirwa. Go ahead, sir.
The third point I want to make is
actually, Mr. Epstein, you have about 5 seconds left.
Okay. Ms. Najambert should not have been considered a respondent in this case, as she has neither an ownership.
That is your time.
Okay. Ahejera mvuga ati ikintu uvuga nuko umufasoni yije imbere atofatwa nk'umuntu yagirizwe na kimwe muri ibi byabaye kuko ntari.
So at this point, I'm going to ask the commissioners if they have any questions for Mr. Epstein. Commissioners, if you.
I'm sorry, ma'am, for the interpretation, Mara, if someone is speaking, I will also try to go as I did with the attorney, just to pause so I can let them know what's being discussed.
Yes. So, Mr. Randall, we're going to get to you.
Actually, I was as a matter of procedure, I just wanted to ask the commission if they might indulge Mr. Epstein and I, only because the pace at which we're allowed to move through our arguments is going to be much slower than perhaps he had prepared for and I prepared for.
I am giving each party 10 minutes and I am keeping track of only when the attorneys are speaking. I am not counting against any time, but we could be here all day, which is not anyone's intent. And I know not the lawyer's intent. Let me pause while that's interpreted. Nope. Okay. So I'm going, and I don't mean to be abrupt, Mr. Randall. It's just that this takes twice as long as a typical hearing, and we still have several hearings left for the day. So I'm going to try to keep the parties on pace. Commissioner questions for the respondents. I see Mr. Ashby. So at this point, the commissioners will be asking questions to Mr. Epstein, and let's pause while that is interpreted so the respondents know what we're doing. Mr. Dushmir, did you need to interpret that for your clients? And actually, if you could keep your microphone on, it would help us know when you're done.
Good.
Thank you. Okay, so Commissioner Ashby, questions for Mr. Epstein.
Yes, I'm interested, Mr. Epstein, in the last argument you were commencing before you ran out of time. Actually, I am interested in hearing what you have to say about the liability or lack thereof of your client's wife.
avuze ati nifuza kubaza ikibazo umuloya wanyu ati caca kugira uvuze ubwa nyuma ni iki ufatiye ko kugira ngo uvuge yuko umufasoni w'umuntu ariko araburana atarimo.
Well, we know from the record that Ms. Nijambert is not an owner of the property, that she is not a party to the lease, was not a party to the lease, and that virtually all of the interactions that took place regarding the rental of this unit were between Mr. Niyokuri and Mr. Hansen. So my position is that under 5 MRS.
Can you pause please for the interpreter?
Yes. Thank you so much. Avuze ati ukuri ndabizi nuko umufasoni Nijambert atari wenyene iyo nzu uyu muntu yababonanje yabamo nyene iyo nzu ni umushinga ntahe niyo nkuru kandi ikindi gihe kabiri nuko nta na hamwe twize tubona yuko hageze haba ikiganiro canke amajambo hagati y'uyu muntu yitwaye n'umufasoni Nijambert. Go ahead.
Thank you.
So my position is under 5 Maine Revised Statutes Section 4581-A1. She does not meet the definition of someone who has the right to rent or manage a housing accommodation. I question whether, given her lack of legal status, she could have, for instance, commenced an eviction proceeding on her own. So that's why I say that she was improperly joined here.
Okay, good. Can you pause? Ati mfatiye kuri iyo teka ariko aravuga nuko kubera umufasoni Nijambert si wenyene iyo nzu kandi nta na hamwe aboneka ari afise ikintu na kimwe ahurirako n'uyu muntu yitwaye muri urubanza. Icyo tuma ni kuri je nibaza yuko atategeka kuza muri urubanza nk'umuntu baburanye. Go ahead, sir. Go ahead, sir.
That was the end of the answer. Jeff, do you have any other questions?
I have no further questions. Thank you.
Great. Jeff avuze ati nta kindi kibazo afise.
Do any other commissioners have questions for Mr. Epstein? Yes, Ed. Oh, sorry.
Hari uwundi muntu umwe muri aba bantu bageze muri komisiyo iyo bafise ikibazo yobaza uyu muntu nshingamanza.
Go ahead, Ed.
Elliot, you say you want to emphasize the civility of the conversations. One of the factual obligations is that complainant was contacted and the respondent screamed at him, said he had to be out by September 1st, and he was on his way to the apartment and would throw his things out the window, and that gay people were executed in Africa, the conjunction of those two things. That certainly is not civil discourse, and that's an example of that happened more than that kind of interaction happened more than once in this case.
Can we
That's-
pause for
Pause,
the
please.
interpreting?
Yeah, uyu mushingantahe yitwa David avuze yuko ngo ni gute wavuze ko ata confrontation yigeze iba hagati ya niyo nkuru n'uyu muntu yitwaye, kandi avuga yuko uyu muntu yitwa avuga yuko niyo nkuru yamukankamiye akanamubwira yuko ibintu bye yobita bishe mu idirisha, kandi akagira na commentaire akagira na commentaire ivuga nabi abantu baba homosexuel.
That's precisely my point, Commissioner David. We have these allegations of all kinds of nasty comments being made on at least 3, perhaps 4 occasions. We don't have a GPS system to tell us which one of these parties is telling us the truth. So we look for any kind of incontrovertible, objective evidence we can find to judge credibility. One of those pieces of evidence is the series of texts that were sent between the parties, which are part of the record. And those show no hint of the kind of florid remarks that have been alleged.
Let's pause.
Yishuye avuga yuko ati ibyo mvuze ndabyumvise kandi ibyo mvuga naje nabyumvise kandi n'ibintu babaje kumva ko umuntu yavuze nk'ibyo, ariko kugira ngo tubyemeze turinda kuronka ibyemezo tabanduka biri ngaho. Ati mwa kintu dufise cyonyine ni ibintu babwiye y'amatext bandikiranye, atari kuyasomye nta na hamwe handitse ibyo bintu uyu muntu yavuga yagiriza niyo nkuru.
Commissioner David.
Go ahead.
You emphasize the need to make judgments about credibility. You certainly don't question that it's reasonable for me as a commissioner to rely on the credibility judgments made by an investigator that I find, based on prior experience, to be thorough, reliable, that stated the evidence that she's made her judgments on. Do you? There's nothing wrong with.
Can we pause while that's interpreted?
Ariko aravuze ati none naho uvuze gutyo jewe nk'umuntu ari muri komisiyo ntiwemera yuko nshobora kumva ibyo umuntu yitwaye yavuze, kandi nkarabona ashaka ari ibyo umuntu yakoze amatohoza yasuye akandika nkabifatira ko kumbure gusa kuba biri ngaho kubyemera cyangwa kubyemera nk'ikibazo mubajije. Go ahead, sir.
The problem, Commissioner David, is that she didn't make those judgments. She said, this is what Mr. Nakuri said happened. This is what Mr. Hansen said happened. Keep in mind that these interviews were done telephonically, so she couldn't even really judge body language and the like. And she ended up saying that one account is as probable as the other account. So
Could you pause, Mr. Epstein?
Ariko aravuga ati ibyo kuravuga ndabyumva, ariko rero na nyine byagenze n'abakoze amatohoza, kandi uwakoze amatohoza ntiyemeje ko byabaye, yavuze gusa ati uyu yavuze, ni nk'uko yasubiyemo ibyo umuntu wese yavuze, avuga ati ubu yavuze ibi, ubu yavuze ibi, ntibisigura ko yabivuze ko byabaye necessary. Ati nta kintu na kimwe kitwereka yuko byabaye, kandi n'ikirenze ko nuko aya matohoza yose yakozwe ku telefone, abantu bavugana ku telefone. So iyo uko bari mu telefone biranagoye no gusoma mu maso hiwe ariko aravuga canke amasinye yogira, ati nico gituma bigoye kuvuga ngo twobifatira. Go ahead, sir.
In my view, the investigator should have taken each piece of evidence and said, this is probable or not probable for the following reasons, and used whatever information there was to corroborate or disprove that evidence. And I've suggested the texts only because at least they're in black and white, and we can compare them to the allegations about verbal conversations. I just don't see that was done.
Hose ikavuga ati kuri jewe ntitwovuga yuko ntitwavuga yuko uko ibintu byagenda cyangwa uko byavuzwe, ntitwavuga yuko ari nta matohoza yimbitse ariho yakozwe, kandi kuri byari kuba byiza umuntu yagize amatohoza yavuga iyo atandukanye akavuga ati iki gituma ca mbere canke igikemezo ca mbere ndagikonsize kubera ibi n'ibi 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 agatanga ibituma ca kabiri ndagikonsize kubera ibi n'ibi n'ibi n'ibi. Ntushobora kuza gusa ngo uvuge ngo ibituma ni ibi kandi utavuze utatanze nawe kumbure ngo usigure neza uvuga uti iki nicemerwa iki nicemerwa kubera ibi n'ibi 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 niko ndabibona jewe. Go ahead.
Actually,
Go ahead,
before you
sir.
do, Commissioner David, is your question answered? Yes, thank you.
Abajije Mushinga David ko ikibazo cishuwe avuga ati yacishuwe.
Any other questions for the investigator at this point from commissioners?
Hari ibibazo bindi byaba bihari mwobaza uyu muntu yagize amatohoza.
Okay, then at this point, the investigator's asking if we can take a 1-minute break, which is not what we would normally do, but I think we need to have the investigator hear the complainant's presentation. So let's do that. Let's take a break for 1 minute.
Reka dufate akaruhuko k'umunota umwe tugaruke.
Okay, let's continue. I believe we have, let's make sure we have complainants, I'm sorry, respondents are here. Okay. Mr. Randall, 10 minutes. I'm only timing your presentation.
Thank you. Aha ijambo uyu mushinga ntahe Randall niwe aserukira uyu muntu yabitwari. Go ahead, sir.
Good morning, members of the commission. My name is Chet Randall, and I am here on behalf of Jason Hansen. In this case, the investigator's report is accurate and it is thorough. The investigator made factual findings supported by all the evidence. Mr. Hansen shared his sexual identity with his landlords. When he did, what had started as a cordial conversation became hostile and the tone changed. The landlords went on to warn that gays are publicly executed in Africa, that they are dragged behind horses, hanged, or set on fire. The tone of the conversation suggested approval. A friend in the house doing laundry witnessed the conversation. These are factual findings by the investigator. These statements were recounted by Mr. Hansen, who the investigator interviewed. The
Can we pause, sir?
interviewed the respondents.
Can we pause, sir? Okay. Ariko avuga yuko kuri we ivyo uko Jason abivuga byagiriza abantu bavuga ko bagirana ikiganiro kandi bariko baravugana hakaba kuduza ijwi canke kuvugira hejuru kandi no kuvuga yuko izo komantere zaba yuko muri Afrika ba homosexuel babica yuko n'uyu yagize amatohoza bigarutse ko yabivuze kandi yerekanye yuko byabaye. Go ahead, sir.
The investigator also interviewed the respondents. The investigator did have an opportunity to consider credibility. These interviews are a significant part of the evidence of any case. I want to address several of the arguments raised in the respondents' disagreement in the comments today, but as an initial matter, it is important to note that a tenant does not need to prove the landlord's conduct was pervasive to establish a hostile housing environment.
Pause. Ati kuri joko nabibona ko ico mfatira cyo ko nabibona uko byagenze nuko n'ubu yagize amatohoza bigarutse ko bivuze kenshi yavyerekanye avuga yuko uyu muntu yitwaye avuga ko bamurenge karimbice bamudiscriminating canke yaba muri avuga ati aho yaba wewe nk'umuntu ari homosexuel environment yabamwo itari environment nziza kuri we bibaza ko abantu bashobora kuba bamwanka canke ivyo bakora byose babikora kubera badakunda abantu bari homosexual. Go ahead, sir.
Mr. Hansen only needs to show that the statements were severe. The investigator here is correct that the statements to Mr. Hansen that gays are publicly executed in Africa, that they are dragged behind horses, hanged or set on fire, in the context in which it was said is severe and adequate to meet Mr. Hansen's burden. Now turning to the respondent's concerns. Respondent complains that a burden of proof.
Avuga ati uko usomye ivyo amatohoza yanditse yavuga yuko Johnson yavuze yuko abantu bamubwiye yuko muri Afrika homosexuel babica babashira babakwega ku mugozi inyuma babaje amafarasi kuri je numva ari ibintu bikomeye kandi numva ko ari ibintu bikomeye batuzasubiza guha agaciro tukumviriza. Yagira bwira uyu muntu waserukira cyane muhagarika. Go again, sir.
Respondents complain that the investigator's report applied the wrong standard when the investigator defined reasonable grounds as an even chance or 50-50 chance. The respondents assert that because the EEOC and its rules relies on a preponderance standards, so should the commission. There is no such standard imposed on the commission, and this commission, to the best of my knowledge, has never issued an opinion stating such. Indeed, the even chance standard has been the prevailing standard for this commission's reports and findings since I have first done a housing discrimination case before you. I am sure the commission counsel will provide further guidance. However, the commission is not in fact interpreting federal law as does the EEOC. It applies state law. Moreover, the preponderance of the evidence standard articulated by the respondents is a standard applied in our courts in most civil cases.
Can you pause for just a minute?
Pause, sir. Donc avuga se mu bya asubiramo cyane avuga ati tufite ibyo twumvise umurebe ariko aravuga umurebe wabo yavuze cyane gose kuvyerekeye ivyemezo amaproof ngene yo kwemerwa cyane ngene boya classifying ariko novuga ati kandi avuga ati kandi iyi commission ntijejwe gusubirira cyangwa ku applyinga ntijejwe gukora nkuko kumbure iyo hari ikindi kintu neza ko ari iteko peut-être ngira lekure amasentara akoresha ikomeye n'isura amasentara yo kumviriza ibyavuzwe ikaraba n'icyo n'imwe mu ko ari sigura hano urayize kuri sigura amakumbure mu nyuma ikaza kubwica yondira nayo. Go ahead, sir.
It strikes me that such a higher standard does not meet the purpose of the Maine Human Rights Act to discourage discrimination and deter. It would turn the process into a judicial fact-finding proceeding and not an agency investigatory action. I want to now turn to the credibility complaints regarding the credibility of the witnesses.
Kandi ko ndabona jewe nuko iyi komisiyo zaguca yumvira kandi kumbure uko byogenda kose bikenewe yuko haba kuvuga ko habaye discrimination canke yari warengeye ubundi kumbure George imbere ya imbere ya sentare kabandanya ati mbona nashaka nishure ku bijanye n'ico bavuze c'umuntu yatanze témoignage. Go ahead, sir.
The respondents complained that the investigator did not evaluate the credibility of a witness who submitted an affidavit in support of Mr. Hansen's complaint. In the written submissions, they complain of surprise. However, the respondents ignore that the affidavit was requested by the investigator in their letter to the parties requesting additional information, which was dated November 29th. The respondents knew then that the affidavit would be submitted to the commission. They knew it would be provided on December 6th as instructed. Indeed, the respondents received the affidavit before submitting their own December 6th submission. In their December 6th letter, they in fact state, today I received an email final submission from Mr. Randall on behalf of Mr. Hansen, which includes a 73 paragraph affidavit. They maintain that Mr. Hansen never mentioned the affiant as a witness. Mr. Hansen did in fact mention the affiant as a witness who heard the conversations, and that is why the investigator requested an affidavit.
Hose, yeah, umva ko asubiyemo asigura cyane rwose wanashaka so n'ibyo twavuze mvuga ati bashaka kwerekana yuko iyo témoignage naho mu avoka wanyu yase n'ushaka kuvuga ati iyo témoignage mugenzi wiwe atariko uyu muntu yatohoje yaravuganye n'impande ze yaravuganye na Johnson arazi n'uwo mutemo wari arazi imiganire bari bafitanye yari kandi yarateguye neza inyishu yiwe yerekana akibavugisha bose yarabandikiye mwese yaramwandikiye amakete avuga ati wewe ivyo dushaka ni urubanza iriho n'ibi wowe bivuze kuri so nawe arategura témoignage yiwe arayirungika ati kandi warashaka jewe nk'umuroya wa Johnson namuronke ndamusaba yuko yotegura témoignage yiwe akayirungikira komisiyo kandi yarabikoze kandi mu gihe gisabwa n'amategeko. Go ahead, sir.
Despite receiving the affidavit before submitting their own submissions requested by the investigator, they did not ask the investigator to interview the applicant. They did not indicate such an interview was necessary to gauge credibility. They did not request that the evidence be remained open. Respondents completely ignore the fact that the statement submitted by a witness by affidavit is a sworn statement. It is not merely the writings of a friend. Moreover, the affidavit here is detailed and specific. The experienced investigator in this case
Nipos ariko aravuga yaragimata avuga ati iki témoignage yagizwe n'uyu muntu ntimwari mukwiye kuyifata mineneko cyangwa kwishira hasi kuko kandi uyu muntu abarana abantu arazi yuko igihe cyose basabye umuntu kuri témoignage baramusaba yuko agira yo apreta na serment donc yandika yuko donc apreta serment kuko donc hay valeur iyo témoignage ko aravuga donc akarahira ati binavuze n'ibyo ni bonne serment ufite muri langage juridique ateje n'ababiri ko nuko iyo témoignage iba ifise uburemere bukwiye. Go ahead, sir.
Respondents completely ignore the fact that the statement submitted by a witness by affidavit is a sworn statement. It is not the mere writings of a friend. The affidavit here is detailed and specific. The experienced investigator in this case is able to determine the credibility of the affiant from the body of the affidavit when read together with the other evidence in the case.
Ashyiramo ubwo byanditse nyine ko uyu mutemo igira témoignage yari yanditse kandi ubwira témoignage aba yashize ko na sama yiwe aba yayisinye no kuvuga ngo arashiramo amadetail yose kuko bisabwa n'amategeko. Rero iyo témoignage naho mugenzi wiwe bamubwiye kuyifata nko merekete umuntu yandikira mugenzi wiwe donc ni témoignage iba yakurikije ko amategeko abisaba akayandika wanashaka ko niyo sama agashaka ko na signature akavuga n'amadetail y'ibyo yumvise y'ibyanze. Go ahead, sir.
Respondents further complain that the affiant is a best friend and therefore not an impartial witness. The respondents seem to confabulate friendship with a willingness to lie. The affiant's statement is made under oath, significantly reducing any likelihood that friends are more likely to lie. Indeed, here, the affiant submitted a statement under oath. Mr. Hansen filed a complaint with the commission asserting facts under oath. Mr. Hansen signed his protection from harassment complaint against the respondents under oath and under penalty of perjury. In contrast, the respondents here have not submitted anything under oath.
Pause.
Yeah. Donc, ça nous passe à bien yavuze avuga ati bafite kandi uyu mutemo naho itemoyaje mutari kumara agaciro bafite yuko yayanditse agashira ko na offer agasinya yarekeye guhabwa agaciro ati kandi kiretse uyu muntu abona abantu avuze yuko avuze ko ivyo yavuzemo yabesha ariko aravuga ko yabesha baravuga gusa yuko batuye agaciro kuko cyane cyane kuri credibility no kuvuga kuri agaciro batuye agaciro ko byavuzwe n'umuntu w'umugenzi we kandi bigoye gufatira gusa ngo byavuze kugira ngo abe ari ibyo bifatwa nka témoignage ariko jewe ko nabibona nuko uyu muntu ivyo yakoze yabikoze bikoje amategeko kandi ashama detail yose y'ibyo yumvise ibyo témoigne asa n'ukusanga umuntu yari yavuze bwa mbere. Go ahead, sir.
The claim of the investigator could judge the credibility of the witnesses here and did. I want to turn now to the claim of absence of other corroborating evidence regarding the incident at Hannaford. The respondents complained that there were not witnesses produced to corroborate the hostile encounter. However, Mr. Hansen was sufficiently upset and moved to take the step of initiating a protection from harassment complaint very soon after. The prompt timing of his actions corroborates that the hostility had indeed escalated. Notably,
hose baravuga ati nashaka se ngaruke kuri ibi bavuga byabereye muri Hannaford ati umuntu yagirizwa avuga yuko umwagiriza atakintu na kimwe gifatika afise kugira ngo avuge yuko ivyo byabereye muri Hannaford atari nico yakoze kugira ngo ivyo bintu habe abandi bantu baza bakavyemeza uretse we nyene yavyivuye acavuga ati ndagenda abwira yuko ivyo bimaze kuba uyu muntu yagiriza yaciye asaba ko hoba hoje kumukingira bya protection order hoje kumukingira iyo vyerekana yuko yagize icyakora inyuma yuko iyo incident ibaye muri Hannaford. Go ahead, sir.
Notably, the investigator did not request additional evidence of the encounter, but importantly, respondents did not either. After reviewing the affidavit of the affiant, they did not ask that the evidence be collected or that the record remain open. I want to turn now to the text messages.
Pose ya akavuga ati ibi rero byabaye muri Hannaford bimaze kuja muri Hannaford cyo nababwira nuko wewe yaciye mbera nk'ushaka yaciye asaba protection kandi yaba uyu muntu wundi babura nta nakimegeza ko ngo ivyo nta kimegeza ko kugira ngo ivyo abihakane kandi uretse yuko je ndikonerekana yuko ivyo bimaze kuba we yagize icakora kugira ngo yerekane yuko ivyo bitari byo kandi n'umuntu yakora matohoza nabo nyene ntiyigeze abihakana ntiyigeze bikoresheje ntiyigeze abihakana ko ivyo bitabaye uko byanditse muri rubanza nuko kandi kinafatira ko nuko uyu muntu bimaze kuba yasabye protection akabandanya yerekana yuko hari ico yakoze kugira ngo ivyo bibandanye urubanza rubandanye. Go ahead.
Next, respondents maintain that the text exchange between the landlords and Mr. Hansen was cordial and did not hint at fear or outrage that one would reasonably expect. What would one reasonably expect a gay man to do when his landlord, who just learned about his sexual orientation, described incidents of violence against gay men with a tone of approval? While the gay man lives in the landlord's building, subject to the landlord's authority. What should Jason have said in a text to that landlord? Perhaps don't say those things to me. They scare me, hurt my feelings. You're out of control. Cases do not require that a victim of harassment confront a harasser, particularly with.
Iyi ni karavuga kuri ya text message yavuguye mu shumaza wayo avuga yuko ati naho avuga yuko muri text message atanakimwe kiboneka ati je nibaza yuko ufashe aturara imisanzwe ububasha umurendo n'abafise ku mutenant ati no washaka ati no vuga ko message ko yanditse arakitana imwe kirimo ati no washaka yandika avuga ati wanteye boba wagize ibi ati kwa message ivuga yerekana ko hari habaye novuga ngo interaction hagati yiwe no mu landlord tinavuga ko ibyo bindi atabibonekamo asa n'uvuga ati none washaka yandike imwe yuko yerekana yuko ati amubwira ati wanteye bwoba twavuganye nabi muri iyo message. Go ahead, sir.
Cases do not require that a victim of harassment confront a harasser, particularly where there is a suggestion of violence and the speaker exercises control and authority like a landlord or employer. When those texts are read only for what Mr. Hansen wrote, they are matter of fact about rent getting paid. There was nothing else that could be expected under the circumstances. The tone of the text is businesslike as you would expect.
Donc bana yerekana avuga ati izo message twifatira ko cyane kuko ni message umutenant yakora mu landlord ati kandi murazi yuko mu landlord ashobora gukwiranya no mukoresha abafise ububasha kanaka ku mutenant nko kumukoresha ububasha kanaka ku mukozi. Go ahead, sir.
I'd like now to address the timing of the main human rights complaint and the complaint for harassment. Respondents speculate that the timing of the main human rights complaint and the protection from harassment complaint are suspect, all intended to extend Mr. Hansen's stay in the unit. But there is nothing about the main human rights complaint process or a protection from a harassment case that prohibits or limits a landlord's ability to proceed to eviction. The landlords could have had their day in court with Mr. Hansen if they believed he was gaming them. If they really believed he was lying, they could have put the evidence to the test in a court, both in the PFH and in the eviction. They did not. Mr. Hansen did not fear eviction. He feared his landlord's potential actions while he lived there and trying to move.
Can we pause?
ariko yerekana avuga ati none ko ati nabo bavuga yuko ivyo ashobora gukora uyu muntu mbona ko ashobora gukora kugira ngo batesha umutwe canke abagore ati ni kubera ki batigeze babishira bagisho bakoze kugira ngo babishire muri sentare canke nabo babitware canke nabo basinaberekana yuko ariko arabagora nta kintu kimwe bigeze bakora gushika ubujeje ntaco bigeze bakora kandi ntibimbwira yuko ivyo ariko arabagize cyangwa ariko aravuga atari byo go ahead sir. Go ahead sir.
Okay, thank you. Lastly, well, next to last, I'd like to address point out to the commission that though not analyzed in this context, the statements made by the landlords here are direct evidence of discrimination that tend to show animus in respondents' interactions with Mr. Hansen. Please keep in mind that there is direct evidence of animus in the statements made, and it is appropriate to find reasonable grounds on that basis.
Ati ico noheza ko canke ico navuga imbere ku meza nuko ivyavuzwe n'uyu murendero cyane n'uyu muntu ariko arabona n'umuntu muserukira nuko birimwo harimo kwerekana harimo iterabwoba canke harimo kurengera akayimbo umuntu canke gutoteza umuntu ati nivyo nsaba komisiyo yuko ibona canke ifatira ko mu kumviza ibirego byanje. Go ahead sir.
I want to finally address the respondents regarding the appropriateness of both parties being named as respondents. In their initial response to the complaint, the respondents indicate that we bought the house on June 1st. They also state that we told him, Mr. Hansen, we would be raising the rent to $1,200. Further, they state we did send him notice to terminate his tenancy on 2 occasions so we could empty out the apartment. Such reference to we in the context of exercise of control suggests joint ownership. While the lease and deed do not mention both respondents, Maine law does not require a recording in the registry of deeds to perfect an interest in property. The statements of the respondents themselves is evidence of ownership.
Ariko avuga ati ikindi bafatira ko nuko uyu landlord nyene inzu yandikiye umutenant umuburanira amubwira yuko baguze iyi nzu mu kwezi kwa gatandatu akaramurungikira wanashaka na notice zibiri zimusaba yuko zimubwira yuko zimubwira yuko yova muri iyo nzu donc atabana yaba umutenant wabo ati kandi kuri je ndabona yuko asa n'uwakoresheje ububasha afise mu landlord mu gushaka gutegeka cyangwa gukoresha igikenye alegare y'umukiriya wanje. Go ahead sir.
I have nothing further at this time and welcome any questions.
Nta kindi se nongera ko ndarinda ibibazo byanyu.
I muted myself. Questions for Mr. Randall? I see Commissioner Ashby. Let's pause while that's interpreted.
Ati ibibazo mubaza Randall kandi ndabona ko hari umuntu ashaka kubaza.
Commissioner.
Mr. Randall, what's the statutory or regulatory authority for the standard and even chance of prevailing in a civil suit that we use in our cases?
I was not able to find any specific statutory or regulatory authority that either supported it or indicated it was not appropriate. The commission has used it repeatedly over the years, but perhaps commission counsel can help provide additional guidance.
Can we pause while that's interpreted?
For interpretation matter, I'm sorry, I didn't catch the question from the commissioner.
The question was, what is the authority for the reasonable chance standard that we use?
Bavuga ati wotubwira namba aho bariho itegeko ritwereka ingene ibintu vyogana shashara muri ka turimo kugira ngo dushobore kumenya neza ico twokora. Nawe yamwisha avuga yuko, can you repeat your answer, sir, if you don't mind?
Yes, I said that I was not, in fact, able to find any statutory or regulatory authority for the standard.
Ati si bon ko bimaze ati wotubwira itegeko canke itegeko canke ingene ibintu bikorwa mu kwerekana yuko ivyo kugira dushobore gukonsidera iyo preuve donc ukwagiriza atanga. Nawe yashavuga ati nta tegeko nashoboye gutora canke ibwiriza nashoboye gutora ryo twereka ingene iyo standard imeze.
But Commissioner Ashby, I'd further state that there's some significant precedential value in the many, many reports that have been issued and findings of this commission that have relied on that standard and applied it for years.
Okay. Ati iyi komisiyo imaze guhura n'imanza zisa n'izo kandi ikagira ico ivuze, kandi nibaza yuko jewe nofatira canke noha uburenganzira iyi komisiyo yumviriza, kuko ibyo imaze gukora ni byinshi bishaka gusa n'ibika tuba tubifatira kugira ngo amakankaya abereze.
What do you think, Barbara? Did Mr. Epstein just tear a hole in the matrix?
Say that again, sir.
Can you clarify your question for the
I'll
interpreter?
clarify my question. I'm asking Commission Counsel, our lawyer, did Mr. Epstein raise an issue that causes us to be concerned about how we conduct our affairs?
Ati ndashaka kubaza uyu muntu ni nk'umunyamategeko w'iwacu komisiyo yacu. Hari ikintu uyu mushingwamanza aburanira aba bantu aburanira domwe, hari ikintu aba yavuze kidutuma twibaza cyangwa twiyumvira ingene dufata ingingo muri iyi komisiyo.
The short answer is no. I assume you want something more than that. So I will direct you. There is no definition. There's just the use of the word reasonable ground in the statute. But
Pause, please.
Sure.
Ati inyishu inyarutse ni oya. Ati nazi ko mushaka ko nova kumbura ibindi byinshi. Ati mugabo nta kintu na kimwe nta teko rihari twebwe ridufasha canke ridutuma dusigura ivyo ijya conclusion bashaka kuvuga ngo ni ibintu bifadika yuko habaye discrimination. Go ahead, man.
Thanks. So looking at the guidance that we issued, there are a series of Commission Counsel memoranda on our website, and our very first Commission Counsel, John Carnes, so many Johns, in 1992, which was 30 years ago, published a memo that's been available in our public records ever since, that talks about the reasonable ground standard. Guessing we need a pause before I launch into it.
Avuze ati nta teko namwe rihari twofatira cyane twokwitwaza, ariko nsubiye magatoya nkaraba abantu bakoze muri komisiyo, hariho memo imwe yigeze kwandikwa n'umuntu yari muri komisiyo mu 1992, tiri imyaka myinshi, imyaka 30. Ati hari ibyo yavuze, ati mbere ko nabivuga reka yabanza ntagaragara dusigurire kwa. Go ahead, man.
And that memo says that our standard is drawn directly from the EEOC standard, which talks about whether there's enough admissible evidence or reason to believe that discovery will provide enough evidence so that there is at least an even chance that the plaintiff will be able to prove in court by a preponderance of the evidence that the discrimination occurred.
For the interpretation matter, you said some abbreviations, so I'm not sure if I understand what it is, or if, how can I let them know what that means?
Yeah, it's Equal Employment Opportunity Commission. It's the federal employment equivalent of us.
Okay, well, thank you. So yavuze yuko ati uwo muntu yavuze yuko twitwaje amategeko ari muri iyo novuga ari muri iyo baca twitwaje ingingo z'iryo tegeko novuga ntiyagarira ukungana ko abantu bose ukungana ko abantu bose yaba abakoresha abakozi bose basa n'abagarutse ku byo ujya mu byo yari yavuze umushikiranganji wayo avuga ati kugira ico twofatira kugira ngo twemeze ko preuve ariyo canke icemeza arico nuko ico kintu kiba cabaye umwanya ukwiye ku buryo umuntu ashobora kwemeza neza yuko cabaye umwanya ukwiye cabaye kirekire hari abantu benshi bakiyemeza kugira ngo ushobore kubifata nka preuve ifadika ushobora kuvuga ngo urabirira umuntu. Go ahead.
Sure. I would also point out that this is a housing case, and in a guidance memorandum from the Department of Housing and Urban Development, their definition of reasonable cause says, reasonable cause exists when one can conclude based on all relevant evidence viewed not as an advocate for either complainant or respondent, but rather objectively in light of the act's language and case law, that a violation may have occurred. And they say that it is somewhere between a reasonable suspicion and the preponderance of the evidence. So less than a preponderance.
Good. Avuze ati ibi nabyo ibi bindi niko ndavuga ni ibyo se ndavuga nuko ni na madecision yarafatwa hano muri komisiyo iwacu kuvuga à l'interne ati mugabo kindi twofata ni komisiyo y'ejo by'amazu cayize ni uburaro bw'abantu biki ingene nayo idefinisa ikintu bafatira ko kugira ngo bavuge ko ico cemezo gikwiye ni mu gihe ikintu cabaye mu mwanya ni mu gihe ikintu cabaye bifata umwanya ukwiye ko kiraba kandi ku buryo atamadidane menshi abariho mu kuvuga ngo uyu muntu bumwagiriza iki cyangwa bumwagiriza iki kuvuga ngo barabira ku mwanya ikintu cyamaze kimwe no kwerekana ingene novuga ngo ibindi byemezo byose biza bivuga rumwe bitavuguruza kugira ngo umuntu yemereye umuntu ashaka avuga ati ko ibi byose tubifise turashaka kwemeza ko ikintu cyabaye. Go ahead, man.
I'm done unless you need anything else, Jeff.
Well, no, I was going to say, thank you, Barbara. I found the 1992 Carnes memorandum exactly where you said it was going to be on our public outward-facing website.
Let's pause.
Ati ibintu rije kuvuga nasanze uko bivuze ariko ugiye no kurondera kuri website ya komisiyo yacu ariko nayo uko babivuze ariko nayo nyene isi ibivuga hafi cyo kumenya ko bivuze.
Now,
and I have
where
no
we
further
left
questions.
off.
No
Okay.
further questions for Mr. Randall.
The commissioner said he does not have any other questions for Mr. Randall. So I was trying to get us back to that point. Were there other commissioners who had questions for Mr. Randall?
Avuze ati nashaka swe tugaruke kuri zo turavuga nyene kuri kaza turavuga hari n'umwe muri aba member b'iyi komisiyo yo bafite ikibazo abaza umushingantahe Randall.
And I do not see any.
Nta n'umwe mbona.
So I think at this point, we would turn to the investigator to present her findings.
Ati ubu rero naho twashaka kubaza ubu yakoze amatohoza kugira ngo tubwire ivyo yatoye.
And I would just note for everyone that so far we've done about an hour and a half on this one hearing. So I'm going to see if I can encourage folks to embrace brevity.
Ati nashaka kuvuga yuko tumaze gukoresha isaha, you say half an hour or just 1 hour?
An hour and a half so far.
Okay. Ko tumaze gukoresha isaha n'inusu kuri urubanza yifuza kusaba abantu bose bogisha bavuga mu nyuma ko bosa n'abasongora. Yes, go ahead.
Good afternoon, commissioners. My name is Jade O'Reilly, and I was the investigator on this case. Oh. Sorry, you're muted.
The interpreter is muted. Yep. But go ahead, Jane.
Okay. So I don't really have anything else to add. I think Commission Counsel handled the question of the the standard used, but I'm happy to address any questions about the factual record and how I reached my conclusion.
Let's pause.
uza ati nta bindi byinshi nokongera ko uyu Honorable aserukirwa ubunye yitwaye yavuze byose, yavuze bitari, yavuze byinshi natwe nari kubivuga, nta kindi numva nokongera ko muri no mwanya kiretse ko uza kwishura ibibazo n'ambazo bikenewe. Go ahead.
Any commissioners, if you have questions for the investigator, I see you, Commissioner Ashby. Anybody in addition? So let's start with Commissioner Ashby.
I have just one.
Actually, just a
sorry.
second while that's interpreted.
Yariko avuga ati ababwira bari muri komisiyo avuga ati hari umwe wafite ikibazo cyo kubaza uyu muntu yagize amatohoza, ndabona yuko hari umwe afite ikibazo yamuhaye umwanya wavuga. Go ahead, sir.
I have just one question. I see your notes accompanying your investigative summary, and you indicate that Micheline Njembe owns the building with her husband. She said those words to you herself?
I will go for abajije ati ndavye abajije yagize amatohoza ndavye ivyo wanditse cyangwa ndavye wanditse uravuga yuko umufasoni nije imbere nawe nyene ari kumwe n'umushinga ntawe wiwe ari nyene iyi nzu nawe nyene ari proprietaire w'iyo nzu atubikura he?
Go ahead, Jane.
So I have my notes from my interview. I have the question I asked was, what is your role in managing the apartments? And her response was, I am Clovis's wife and we bought the house together.
Thank you.
Avuze ati ndafise ibyanditse igihe nariko ndakora amatohoza yanje twaravuganye na mufasoni nije imbere ndamubaza nti wowe none aka wewe uhuriye n'ibiriko biraba ataranyishura ati ndi umufasoni wa niyo nkuru ndi umugore wa niyo mufasoni wa niyo nkuru ati kandi iyo nzu twayiguze turi kumwe. Oh, okay.
No, we are not taking any testimony from either of the respondents.
Any question too?
No questions. Just
Okay,
interpreting.
Okay, nta kibazo bafata nta tumanye bafata no kweterepeta gusa. Yes.
Additional questions for the investigator from commissioners.
Hari uwundi muntu muri aba bagize iyi komisiyo yabafise ikibazo abaza bagize amatohoza.
I do not see any commissioners indicating that they have questions for the investigator.
Ati nta muntu umwe mbona afise ikibazo kuri uyagize amatohoza.
So at this time, it's up to commissioners to make a motion or motions, and let's wait while that is interpreted. Although
ati rero muri iki gihe tugeze aho aba bagize iyi komisiyo umwe wese yovuga ingingo ashaka gufata.
Commissioner David.
I move that the commission find that there are reasonable grounds to believe that respondents discriminated against complainant on the basis of sexual orientation and conciliation should be attempted.
Let's wait while that's interpreted.
If you don't mind, can you say that again, please?
Ed, can you repeat that?
Yes, I'm reading from the recommendation. I move that the commission find that there are reasonable grounds to believe that respondents discriminated against complainant on the basis of sexual orientation and that conciliation should be attempted.
Ati jewe demeza afatiye kuri byanditse yuko uyu aburanywa ashobora kuba yararengeye canke yararengeye canke yararengeye yaradiscriminatenze umuntu uwo muntu yaramupangiye yifuza yuko hoba ukumvikana.
And Commissioner Whitworth seconded the motion. So the motion is to find reasonable grounds to believe that unlawful discrimination occurred. Is there any discussion among commissioners? Let's wait while that's interpreted.
Avuze yuko uwavuze ubwa mbere yavuze yuko wewe ivyo byavuzwe ko uko bimeze avuze yuko byemeje. Tewe igikomeye ubonye ikurikira mwese muri hano kuvuga ko ibyo murabishigikiye cyangwa murabihakana cyangwa muri gwanya.
Any commissioner discussion?
hari ushaka icyo avuga?
Seeing none, I will call the motion and ask each commissioner if they agree with the proposed finding that the respondents unlawfully discriminated against Mr. Hansen.
Ko atanumwe yagize icyo avuga kuri ibyo, uroshaka rero mbaze umwe wese muri abagize iyi komisiyo ko bemeza canke bahakana ivyo uyu mushinga mbere yavuze yemeje.
Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Dusan,
Yes.
Commissioner O'Brien.
No.
So the vote is 4 in favor of a finding of reasonable grounds and 1 opposed to that. So the commission's finding is that there are reasonable grounds to believe that Mr. Nyakuri and Ms. Najambere discriminated against Mr. Hansen.
Yavuze yuko amajwi ane yavuze ego, ijwi rimwe ryavuze oya. Rero ni ukuvuga ko komisiyo yevoluye ivuga yuko Nyakuri na Nijimbere barengeye akarimbi cyangwa habaye discrimination contre umuntu yabapangiye inzu.
And the commission will send all of the parties and lawyers a letter describing the finding and the next step in our process.
Kandi komisiyo izoheza ironke ikete abashingwamanza babo umwe wese ingene n'umunsi byagenze inavuge ico kurikira.
And that is the end of our hearing on this case.
Aho niho duhereje no munsi kumviriza urubanza.
So we have 2 cases left to hear. Commissioners, do you want to take a 5-minute break or keep going?
Keep going.
Okay,
Just my vote.
well, no one else has said anything, so,
Agreed.
okay, let's keep going.
Sorry. So our next case, H21-0370-A John Griffith v. Green Tree Associates and Weston Associates Management Company. Also Weston Associates Management Company, Inc. It is a no reasonable grounds recommendation. So is there anybody here for the claimant?
Mr. Griffin is here. Do you want to unmute yourself, Mr. Griffin?
How's
There you
that?
go. That's great. You'll have 10 minutes.
Okay. Am I go now?
Go now. Yep.
Thank you for giving me the opportunity to speak here today. Issues I have with the investors report, complainant's evidence and documents were pictures that was not given the same consideration as the respondents' verbal responses from both complainants. December 23rd, 2020 and December 8th, 2021. Summary of the case, the investigator's report does not recognize the date or changes when my home and mailing address officially changed. I sent an email indicating the actual date that it took place, October 25th, 2021. Original change was to be done June 1st, 2019. The premises 50 New England Road, Apartment 1. Electronic notification was sent on October 25th, 2021 at 6:40 a.m. Analysis and facts of findings. On May 1st, property manager received a letter from the local code enforcement officer that due to a recent emergency response delay, complainant's unit needed to be renumbered for his physical address and his mail would be properly delivered to the mailbox cluster in the complex. During the IRC, complainant stated that he had issues with his mail. It sometimes impacted his disabilities because of medication not being timely received, like blood pressure medicines. Regional property manager verbally stated complainant's physical address had changed, but not his mailing address. December 8th through 2020 through December 23rd, 2021, The complainant provided evidence the apartment read 151 and the building read 15, which is not what the code enforcement officer directed Weston to do. Fact is, the change was done the morning that I picked up and delivered the copy of the police report to the investigator when I did not receive my medications on the expected date because my address was not correctly changed. B, legal analysis, the fact that the complainant continued to observe car sales throughout 2020 and 2021 and his ongoing mail issues arguably gives rise to a reasonable inference of discrimination for the purpose of complainant's prima facie case. Respondents in turn articulated a legitimate, non-discriminatory reason for their actions, namely they treat all tenants the same and did not allow any tenants to operate a business at the property and did not interfere with complainant's mail. When a tenant provides credible concrete evidence about lease violations, respondents take action. Fact, respondents were never asked to produce evidence. The address change was only verbal answers only. Fact, complainant produced pictures and emails that it wasn't done by October of 2021. Fact, evidence provided to property manager with a brief statement of cars being sold by the tenant in apartment 3 that indicated a picture from another tenant and nothing happened. No lease violation was written. That was not included in the investigator's report. Fact, respondents provided this information only after the close of evidence. Fact, first filing, complainant also produced evidence that this tenant in building 49, apartment 3, advertised cars for sale on Craigslist. Fact, complainant included a photo of a car carrier bringing cars to building 5, the dealer. Fact, answers given by a respondent in the second filing were different than the first filing, stating it was okay to bring a car to this property from the dealership to finalize the sales or transfer. As for complainant's mail and apartment renumbering, instead, respondents verbally provided that they did comply with code enforcement requests, which related to only complainant's physical address and not his mailing address. Fact, the above statement doesn't even make sense to change the physical address and not the cluster box. In fact, it suggested there would be 2 different mailings addresses for the same location and also providing a false address. During both filings, verbally respondents answered they do not have control over the individuals that deliver complainant's packages or what's on those mailing labels. Fact, my apartment number nor the mailbox cluster were changed until October 25th, 2021. Fact, complainant gave email copies he sent to code enforcement stating it wasn't done. Investigators report December 8, 2021. The complainant provided photographs of recent car sales in progress in September 2021 of a vehicle dropped off by a flatbed during the middle of the day. Fact, complainant's evidence, pictures were provided of this car being offered for sale to different customers. Fact, management and maintenance personnel from both Augusta and Bangor had the opportunity to see this car with no plates on that vehicle and the opportunity to see it being offered for sale in the middle of the day while they were here in this area mowing the lawn. The office manager was inspecting the common area and speaking to other tenants in building 49, apartment 1 and 2. She drove right by the car that had no plates while she was driving the golf cart while maintenance staff mowed and weed whacked in this common area. C, the first filing of evidence provided by the respondent showed that other violations over the years, the same tenant in 49, apartment 3, has had verbal warnings, written warnings for selling cars, written violations for unregistered cars, written violations for working on cars, written violations for using his apartment as a place to operate a business from their apartment. In both filings, I provided pictures of numerous cars in this parking lot with and without plates, including cars and trucks being offered for sale to different customers. D, fact, when a disabled person asked for reasonable accommodation for a change in house rules and was denied because respondents claim it's an undue burden to the way this company operates and was given no option for further discussion. E, fact, during my second filing of this complaint, I did some investigating on my own, trying to get written statements about car sales conducted by the tenants in building 5. I found out that the other tenant in Building 5, the dealership had moved during the first filing of my complaint. But yet, when the respondents were asked for a list of reasonable accommodations and how many reasonable requests were asked for and received, this tenant was not listed, but yet runs a car dealership. Last known address was 1 McKinsey Circle, Norwich Walk, Maine. He did admit his cars were in fact stored on Green Tree property. Fact, this tenant did not need a reasonable accommodation to store those cars or remove from a 2-bedroom unit to another 2-bedroom unit. Fact, no written violation was issued for using property for his business to store cars on this property. Respondents failed to mention that in the list provided to the investigator. Fact, complainant also provided the Secretary of State requirements to operate as a car dealer and city requirements for a secondhand dealer, pawn shop, or selling jewelry. Fact, this is clearly unequal or segregation of treatment for all tenants in regards to privileges and services. The first complaint questions were asked to the respondent. Question 12, with regard to complainant's request for accommodations, please provide the following. Why it would be too expensive for you to grant this accommodation? Explain in detail why it would be an undue administrative burden to grant this accommodation. Explain in detail why it would alter the type of housing services you provide. Explain in detail why this request is unreasonable. Respondent's answer given, it says C number 2. Fact, I would have a paper trail documenting my sales and income where these car sales do not. A dealership license and zoning requirements are more strict in regards to operation than the permit I needed. Question 15 asks for his disability status for those other tenants in question. Respondent's answer, no information on the disability status. Fact, this also indicates no need for any reasonable accommodation requests from either of those tenants to sell cars or to move from one apartment to another of the same size. Conclusion, disabled versus non-disabled, the rules are not applied equally to all, particularly when comparing used car sales with customers coming to the property versus selling jewelry online or off property with no customers. Thank you very much for granting me the opportunity to speak.
Thank you.
Sorry, I rattled it off so quick. I had to get it.
Any commissioner questions for Mr. Griffin at this time? Seeing none at the moment. You'll have just over a minute left when we come back to you. Next, we would go to respond. Is there anyone here for Green Tree or Weston and Associates? I saw Mr. Van Bars before.
Yes, I'm here. Good afternoon.
You'll have 10 minutes. I don't know if you wanted to go on screen, but you're not on screen.
Well, that's because I don't have a camera hooked up to this computer.
Okay. All right then. Phone works too.
Didn't expect I'd be on that long anyway.
Yeah.
I represent Green Tree Associates and Weston Associates. I assume the commissioners have all noticed that this is not the first complaint based on these allegations. The first complaint was dealt with, I believe at February 2021 commission meeting, and no reasonable grounds were found at that time. Much of what Mr. Griffin just addressed in his statement was evidence he presented in that first complaint. This second complaint, although the investigator's recommendation is for a finding of no reasonable grounds and it's favorable to my clients, I do not believe that the analysis is quite accurate. She stated that the complainant established a prima facie case of discrimination. However, 2 of the 3 factors necessary for that finding have not been shown by the complainant. The second factor of the 3 that he is required to show is that he was not offered the same terms, conditions, or privileges of rental that were made available to others. The third factor is that the circumstances give rise to a reasonable inference of prohibited discrimination. As to the second factor, Mr. Griffin has produced absolutely no evidence that a business is being run out of an apartment at Green Tree, or more importantly, that one is being operated with the knowledge of or permission from the owner or manager. The investigator's findings are that he observed, quote, alleged car sales, close quote, my quotations, but didn't report those to the respondent. The fact that he saw what he thinks are car sales, and maybe they were, but the fact that he saw them does not mean that someone is running a business out of the apartment. As stated in our response, they could simply be facilitating the transfer of the vehicle in the parking lot because it's convenient. Nevertheless, he didn't report this from the time of the last case until this case to the respondents. He presented plenty of pictures and emails and other items in support of his claim, but none of it was given to my clients before he filed the complaint. The fact that he thinks there are car sales going on does not mean it's happening. It's his burden to show that there's a business being run out of there and it's being run with my client's knowledge and permission. That has not been shown. As for the mailbox, he hasn't shown that he's the only tenant at the property who is not having his mail delivered properly. And in fact, the evidence presented was that there are several other tenants who have had similar issues with their mail. Whether the apartment number and building number were changed in a appropriate amount of time is not relevant to the issue. What's relevant is his mail being interrupted because of his disability, where other tenants' mail is not being disrupted because they're not disabled. And there's no showing that that's the case here. So respondents do not believe that Mr. Griffin has in fact established a prima facie case, but even if he had, respondents provided legitimate, non-discriminatory reasons for the actions that they've taken in this matter. And I would urge the commissioners to find no reasonable grounds. Thank you.
Thank you. Commissioner, questions for Mr. Van Bars? Seeing none. Mr. Griffin, you have a little over a minute left. Do you have something you want to add?
It was directed to these two individual buildings. This one right here, 50 and 49, and that was back in 2019, and it has made my medications delivery is complicated, taking them on a timely management process like I'm supposed to. You know, like blood pressure pills, there is side effects when you stop abruptly taking pills for your blood pressure and then restarting them again. I don't see why he can sit there and say that they responded to it in a timely fashion. My mail was getting returned. All this for the mail address issue was being addressed because of that city code enforcement letter that was sent to the office first for Green Tree and Weston that was neglected from 2019 through 2021. I have medications, which I'm not even going to try to pronounce, but I will get the medication and show you so you can
Nope,
see it.
nope, no, thank you.
It freezes.
Mr.
and it's-
Griffin, we do
it
not
should-
want to see your medication. You have about 5 seconds left to finish what you have to say.
As far as car sales going on, they've known about it. If they didn't know about it, why are they issuing lease violations and not stopping it?
Okay. I appreciate that's your time. Let me see if commissioners have any questions for you. Commissioners, any questions for Mr. Griffin? Seeing none. Mr. Van Bars, you have 5 minutes remaining.
Thank you. My
Do you want-
clients knew about Mr. Griffin's complaints about car sales at the time of the previous complaint that he filed with the commission. They had sent out warning notices to the affected tenants and have had no reports of car sales since then. As for the mail, I did not state that my clients timely changed the building and apartment numbers per code enforcement's recommendation. I stated that they did eventually do it, and it had no effect on Mr. Griffin alone, as opposed to all of the other tenants at the property. Thank you.
Any commissioner questions for Mr. Van Bars? Seeing none. Thank you, Mr. Van Bars. Thank you, Mr. Griffin. At this point, we would turn to our investigator.
Apologies. Hello again, everyone. My name is Alex Finley. I was not the investigator on this case. I inherited this from investigator Alice Neal, but based on the record, which I read in preparation for this meeting and what I've heard today, I'm inclined to believe, inclined to agree with investigator Alice Neal's recommendation. I don't think I have anything else to add at this time, but I am open to any questions.
Thanks, Alex. Commissioner questions for the investigator? Seeing none. Okay, thank you, Alex. So commissioners, at this time, we would be looking for a proposed finding. There's one recommended finding.
I'll move that we adopt the recommendation of the investigator that there are no reasonable grounds to believe that respondent discriminated against complainant on the basis of disability, color, and/or race in the terms and conditions of his housing, and the complaint should be dismissed.
Second.
Just to clarify, the motion said respondent. Were you referring to all respondents? Or a
Yes.
particular respondent? Okay.
No, all, sorry, plural.
Yep. And Commissioner Ashby, was that you that seconded?
Yes.
Okay, thank you. So it's been moved and seconded. Is there discussion among commissioners? I am not seeing any. So the motion is to find no reasonable grounds to believe that respondents discriminated against Mr. Griffin on any protected class basis that he alleged. And if you say yes, then you are in agreement with that finding. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Dusan,
Yes.
Commissioner O'Brien.
Yes.
Okay, the finding in that case is that there are no reasonable grounds to believe unlawful discrimination occurred, and the commission will send parties and counsel a letter confirming that. Thank you very much for your patience today.
Moving to our last case of today, H21-0392, W.G. Diggles and Annette Kennerly v. Wells Moody Campground Condominium Association. It is a reasonable grounds recommendation. Is there anybody here from the respondent?
Yeah, yes, Attorney Tom Mischio for the respondents, Your Honor, or ma'am.
You have 10 minutes. Go ahead.
Thank you. So I'll try not to rehash any of the arguments we've made previous to today, but I want to touch on a couple of points that I think are most relevant to this commission's determination. Wells Moody Campground is a seasonal campground pursuant to the ordinances in the town of Wells. The town of Wells requires the campground to be closed in the off season and particularly delineates the dates during which the off season is. The way in which Wells Moody Campground has enforced that law, that ordinance, is to shut the campground down during the off season, to include putting a chain up across the vehicular access road into the campground. They've done that the entirety of time the campground's been open. The association board has always enforced that town ordinance in that manner. And they do so for a variety of reasons, which we touched on. It prevents vehicular access. The roads are not maintained. The common areas are not maintained in the off season. The majority of residents, not the majority of the residents, a portion of the residents aren't even local. They travel to Florida or Arizona or elsewhere during the off season. There's no way to prevent foot traffic into the campground, but the vehicular access plus shutting off all the water and electricity to the campground is how the town enforces that ordinance. If the complainant's request was granted, that would open up the campground to vehicular traffic, which would expose the campground to liability, both under the ordinance as well as liability for anything that takes place on campground grounds. If there was an accident, if someone slipped and fall, any of those things that take place, the association would be responsible for that, those conduct. In addition, turning to the Maine Condominium Act, particularly section 4583, stating that nothing in the act may be construed to prohibit or limit the exercise of privilege of the agent having the right to enforce specifications in letting or in the furnishing of facilities or services in connection with the facilities that are consistent with the business necessity and are not based on the physical, mental disability. In this case, the business necessity of this association is to limit the liability of the campground association. They do so in the manner in which they've chosen to prohibit vehicular access in the off season. One of the things the investigator touched on in her report was citing a case that talked about, hold on one sec. Yes. The complainant made their initial showing, the respondent can defeat the claim by showing the proposed accommodation was unreasonable, meaning it imposes an undue financial or administrative burden or requires a fundamental alteration in the nature of the program. The argument we're making is that allowing the complainant access by giving them a key to the gate changes the fundamental nature of this campground. It's an off-season campground. It's only open during the summer. Allowing anyone in a vehicular manner in the off-season would fundamentally change that and expose them to liability for violating the town ordinance. There are no vehicles allowed in the off-season except for any contracted for services, and that's controlled through the manager and the keys that provided to a part-time quote-unquote security officer in the off-season. One of the statements made by the complainant in their response to our written submission is to cite to the declarations in place in this condo association, specifically section 6.2 stating the executive board shall not and cannot establish any rules or regulations depriving any unit owner of reasonable ingress, egress, and regress to and from the unit. It's our position that the locking of the gate in the off season is a reasonable restriction on a unit owner's movements. For the reasons I've already stated, it exposes the association to liability both through town ordinances as well as any actions that take place in the off season when the access would have been granted. Based on everything I've said today, as well as our submissions prior to today, I would submit to the commission that they find the investigator's report, reject that finding in the investigator's report. And I would reserve any additional time for rebuttal.
Okay. Commissioner questions for Mr. Missio. I probably pronounced that wrong and I'm sorry.
That's all right.
Commissioner questions. If you have a question, commissioners, let's raise hands. I do not. Why can I hear myself? There's an echo somewhere. Okay. Commissioner David.
Yes, Attorney Michaud, you agree, do you not, that there are, yeah, there certainly is some feedback coming through somebody's microphone.
I think it's Mr. I'm going to try muting Mr. Missio.
Yeah, that seems to cure it. You would agree, would you not, that there is a tolerance and even an expectation that owners are allowed to go in on foot to check their own property, apparently as often as they want or after every storm or whatever. Is that not the case?
I don't know if I would phrase it in that manner. There's no way to prevent foot traffic from entering the campground. It's not as if there's a wall or a fence preventing access. Given the physical nature of the space, that's just not possible. It's not prohibited in any way. You can access your unit, but the units are shut down. There's no vehicular access, and to require additional enforcement to prevent foot traffic would just be financially not possible.
It would also violate the lease that you read, that the board can't prevent access of owners.
And I would disagree with that. I think that again, the interpretation, reasonable ingress and egress. So reasonable restrictions would include closing it down in its entirety in the off season to not violate the town ordinance.
No, that's all.
Any other commissioner questions for Mr. Missio?
Well, Amy, I'm sorry, there is one more. Is it not, I believe you described that you have a manager who can arrange for access for contractual services as necessary, and you have a security guard that patrols on whatever schedule he patrols. So there's two other people that could be contacted for access, correct?
Correct. No, and I apologize for the confusion. There's one person who has a key during the off season who's present on site. The manager, the board member who has a key is in Florida during the off season. So there's only one person, and I use the term security guard loosely because they're not really, they go in every once in a while to patrol the grounds. It's really just to look around to see if there's any damage or anything going on inside. It's not as if they're providing security.
Commissioner David, are you all set? Okay. Any other questions from commissioners for Mr. Missio? Seeing none. All right, you'll have about 5 minutes left after we hear from Mr. Diggles. Mr. Diggles,
Yes,
you have 10 minutes.
okay, thank you. All right, I'm gonna read as fast as I can some pieces here from my notes supporting the investigator's report. The details of Annette's multiple physical, cognitive, and speech disabilities, as well as my own walking disability, are in the record. The respondent claims there is no discrimination because all owners have pedestrian access. Not all owners are capable of pedestrian access, so not all owners have access. The respondent's answer claimed Town Ordinance 14550 prohibits off-season access, and it does not. It prohibits off-season residency. We own our property year-round. We need to maintain our property year-round. I've submitted evidence in writing, photos, and a witness statement documenting our board having selectively granted off-season access for at least 10 other vehicles and having permitted owners to store at least 3 at units over the off-season. Their answer also cites Association Regulation 8 to deny us access. Regulation 8 says vehicles cannot be left in the park in the off-season. As I stated in the IRC, it's only common sense that a person incapable of walking in won't walk out. So it's not even possible for us to leave our vehicle in the park. The respondent also says Section 1601-106 of the Maine Condo Act supports denying us access. Your investigator was able to see that it doesn't. In the record is the wording of Section 1603-102, which we just heard. The Maine Condo Act limits the powers of all condo associations, year-round or seasonal, by saying the association may not deny a unit owner or occupant access. Also in the record is the declaration, which says the executive board shall not and cannot establish rules or regulations depriving any unit owner of reasonable ingress and egress. It's reasonable to go in and check your property as property owners do in the off-season all over the town of Wells. Our common element access lanes are owned equally by all members of the condo and serve as our right-of-way to our property. Maine courts have consistently ruled there can be no lock barriers across any right-of-way to which the owner of a landlocked property does not have a key. The investigator correctly found providing disabled access would violate no laws, but the law does require reasonable accommodations. In our case, a padlock key, $3, hardly a financial hardship and certainly not an administrative hardship. The answer claimed they had no knowledge of maintenance issues that occur in the off-season. Your investigators saw my written and photo evidence proving that claim was false. And as stated in her report, in the IRC, board members confirmed they knew of such issues. The answer claimed they had no knowledge of Annette's medical issues and disabilities. And in the IRC, your investigator learned that was another false claim. 3 other excuses the respondents cite repeatedly to deny access are no more than unfounded conjecture. And their own statements in the IRC prove that. Your investigator found those speculations have no basis in fact, and they do not nullify the Act's requirement to make a reasonable accommodation. An email is included in the witness statement in which our board president wrote, and I'll quote, "Foot traffic is always encouraged," end quote. But in the IRC, your investigator heard him backpedal away from that position by claiming pedestrian access is not condoned, allowed, or approved of by the board. It can't be both ways. The 3rd paragraph of the respondent's letter of January 3rd argues we are not being denied the opportunity to use and enjoy our property, but they are applying their own narrow definition to the words use and enjoy. When I go to check on our unit, Annette is denied the opportunity to use it simply to be there with me rather than being left sitting alone, unattended and helpless 700 feet out of my view. We both are denied the opportunity to enjoy peace of mind and knowing she's safe and I'm close at hand to attend to her. The witness statement, which includes emails and letters, documents denials of access to a disabled owner in 2011 and a disabled occupant in 2018. Now, at 52 minutes and 30 seconds into the IRC audio recording, we hear the board president explaining that if they give us a key, and I'll quote, then someone else may come in with a request for whatever reason. So the best way to control it is not get into the situation to begin with, end quote. The evidence is clear that this condo association has refused to accommodate disabled access for at least 10 years. And that evidence supports a finding of reasonable grounds. That's all I have. Thank you.
Thank you, Mr. Diggles. Any commissioner questions for Mr. Diggles at this time? Commissioner O'Brien?
Just one very quick question. There were four unit owners are on the board, correct?
There were 5, but one sold his unit
Okay,
at
but
the end of the season, and they haven't replaced him. They will in the spring.
okay, but how many total units are there? Do you know?
How many total units?
Yeah, yeah.
Some of there's, I believe, 81 lots.
Okay,
or
okay. I just wanted to make sure it was more than 5. Okay.
Oh,
got
yeah.
it. Okay, thank you.
Commissioner David?
Mr. Diggles, there's no suggestion that you go and want to stay or even stay overnight, right? We want to go to check your property?
Right. There's damages that occur in the off season, particularly because we're within a half mile of the ocean.
I understand. Yeah.
We get wind damage and.
Thank you.
Okay.
Any other questions from commissioners for Mr. Diggles? Seeing none, I'm going to go back to Mr. Miskio. I'm pretty sure I just pronounced your name wrong a different way. You have 5 minutes remaining.
Thank you. And just no one worry about my name. It's pronounced a whole bunch of different ways. It's all good. So just a couple of points in rebuttal to Mr. Diggle's statements. The commission does have a witness statement from a Theodore Wittenkraus.
No names.
Sorry, as a witness statement from a different unit owner. I've been listening all day to the different complainants and hearings going on today. And so I know one of the things the commission is concerned about is the credibility of different witnesses. The only thing I would like to state on that particular witness statement is that individual individually has sued Wells Moody as well, making a similar allegation, which in our mind casts some doubt on the statement that was made, that's been made part of this record. Just an interesting quirk of this case is one of the things Mr. Diggles just argued is that they have a right of way, unit owners have a right of way across this road going into the campground. And there's some case law or some law on point that says that there can be no barrier across that right of way. The association is putting up the barrier. The association represents all the unit owners. So that's an interesting little quirk of the facts of this case in terms of how those two things come into play. Commissioner O'Brien asked the question as whether those board members are unit holders, and they are. So it's an interesting play between those two factual scenarios. One of the things that I highlighted in my written submission and failed to do earlier is something I disagree with Investigator O'Reilly about in terms of her factual conclusion. She asked each commissioner during the investigation phase of this process whether they were aware of any criminal activity or vandalism taking place in the campground during the off season, and none of the commissioners could. None of the board members could. The conclusion that Investigator O'Reilly took from that was that there's no need for the gate. I think a more reasonable conclusion is that the gate is working. There isn't any for that reason, because you can't get in with your car or your truck or your four-wheeler to the campground. And that's what prevents these things. So that is a valid concern that the association has in preventing vehicular access in the off season. That's all I have for the commission. Thank you.
Thank you. Any questions from commissioners for Mr. Missio? Seeing none. Mr. Diggles, you have about 3 minutes left.
Okay. One, I don't understand how the fact that the person who supplies a witness statement, who's also been denied access, somehow lessens his credibility. If anything, it just demonstrates that he's been a victim of the same policy. So I don't see that argument as holding any water. The other thing would be the fact that the chain is up would lend some some validity to the idea that it prevents crime and vandalism, but giving us a key is not going to create vandalism and crime. We're an owner. We're not going in there to damage property. We're not given a key. We're not hanging the key on a tree so anyone can use it. So I don't see that argument carries any weight. I don't know what else I can say. I'm done.
Any follow-up questions from commissioners for Mr. Diggles? Seeing none. Thank you, Mr. Diggles. So now we've heard from the parties and we would turn to the investigator, Ms. O'Reilly.
Good afternoon, commissioners. My name is Jane O'Reilly. I was the investigator on this case. I don't have anything to add to the arguments by the parties. I think they outlined the arguments presented in the investigation clearly. I will just state, since respondent counsel stated I made a conclusion that the chain was not necessary because there had been no vandalism. That is not from my report. I did not make a conclusion that how effective the chain was regarding vandalism. It was a specific response to respondents' rebuttal of their argument that the chain, that they couldn't provide a key, was that it would increase the risk of vandalism or crime on the property. So my asking that question was to see the basis for that concern. Was there a valid basis based on past history of crime that increasing access would somehow increase that chance? So those were the questions that I was asking. It was not to determine the effectiveness of the chain itself. So I just wanted to clarify that. I'm happy to answer any questions.
Thank you. Any questions for the investigator from commissioners? Seeing none. Nope. Thank you, Jane. So commissioners, we've heard from the parties and the investigator. At this point, we would need a motion. There is one proposed finding.
I'd like to make a motion that we find that there are reasonable grounds to believe that respondent Wells Moody discriminated against complainants on the basis of their disability, and the conciliation should be attempted.
Second.
So the motion is to find reasonable grounds. It's been made and seconded. Is there any discussion among commissioners?
Well, just I want to compliment Jane on this report. I think that she effectively dealt with every argument and just took them down one right after another. I can think of 3 or 4 ways that they could allow access. They could get a digital lock and change the PIN, make a prearrangement with Mr. Diggles that he had, 8 hours to go, and then they'll change the lock again. I mean, there's all kinds of ways. All they've proven is that they really don't want to accommodate it, and they're trying to make up excuses. It's open and shut in my mind.
I think even if we don't ascribe any sort of intent on the part of the respondent, I think this is a case of just a failure to understand the duty to accommodate. It's the argument, we treat everybody exactly the same way, and if we give a key to you, we have to give a key to everybody else, is actually not accurate. That's not how reasonable accommodation works. You only need to give a key or make some other accommodation to people who otherwise can't enjoy the benefits of, in this case, the tenancy, such as able-bodied people can enjoy it. So that's the only obligation you have. And you can take that counsel back to your client and tell them if we do in fact rule in favor of the motion, it doesn't mean that they need to give a key to everybody or treat everybody differently or anything like that. That's not how reasonable accommodation works.
Any additional discussion from commissioners? Seeing none. The motion is to find reasonable grounds to believe that respondent discriminated against the complainants on the basis of disability. If you say yes, you are in agreement. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Thank you. Commissioner David.
Yes.
Commissioner Doosan.
Yes.
Commissioner O'Brien.
Yes.
So the finding is that there are reasonable grounds. The commission will send the parties and lawyers a letter confirming that and setting out the next steps in the process. Thank you both for your patience in waiting for this hearing, but it is concluded. And at this point, we would go into executive session. This link to the main meeting will stay open. Do commissioners need a 5-minute break before we do that, or you want to just go into it? Go ahead, that's what I'm seeing. Okay. So first we need a motion to go into executive session that cites the statute. I know everybody's pulling it up. I know.
We rely on Deb to.
I know. It always ends up being one person. It is equally available to all, just to be clear.
Madam
Sorry, I
Chair,
was
saw
on mute.
Your lips moving. You were
Pursuant,
muted. Yeah.
oh, God.
Go ahead. Go, you were muted. I was just
Go.
letting you know.
Okay, thank you. Second?
No, no one has made the motion yet.
Oh, I'm so sorry. Pursuant to 1 MRS Section 4056E, I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
Commissioner Dusan, I believe you seconded that, but I didn't hear you. Did. Okay. Motion to go into executive session. If you say yes, you're in agreement. Commissioner Whitworth,
Yes.
Commissioner Ashby.
Yes.
Thank you.
Yes.
Commissioner David, Commissioner Dusan,
Yes.
Commissioner O'Brien.
Yes.
Okay, with that, I'm going to move everyone hopefully into executive session. All right, so how many commissioners? 1, 2, 3, 4. We're missing Jill. Which it just seems like it would be polite to have her come back before we, plus I can stare at that cute baby for a while more. Hi, cute baby.
Whose baby is that?
This is my 10th grandchild and I watch her all day. So I could hear her. My daughter was upstairs with her and I kept hearing her crying all morning.
Oh.
So
did you say I also want to cry, but instead you were an adult?
I really did.
Yeah. Well, it may be that we lost Jill in translation. Oh, there she is. Okay. We were wondering where you went. There you are. All right. So all
I think the
commissioners-
difference, Amy, is that you don't have to wait for you to close the room, which may take 60 seconds. I think we all just hit leave and it's instantaneous.
Okay, so I do not believe there are any outstanding matters for commissioners to decide at this time. So I believe we don't need a motion to adjourn, but if someone wants to make one, you can, or you can just hang up. Barbara, you are muted.
Barbara, are we going to connect soon? Because I need to do some things.
I'm gonna just hang up. See you guys.
Just hang up.
All right.
See you in March.